that a quorum question or an existential question?
Quorum.
Apparently, Senator Kinski is our lone senator.
No, Sherry Steinmetz was here a minute ago.
She's not a voter.
Oh, they must think it's 8:30.
We are now live on YouTube.
Well, between now and 8:30, I say we go ahead and mark the whole budget up before the other senators get here.
Senator Hicks is coming in now.
And Mr. Chairman, this is Representative Summers. Once again, if you have the Supreme Court go through the book page by page, it'll help me. Their budget is always a challenge. Just it looks different, so it's harder to follow it.
Yeah, I agree with the Supreme Court. With the district courts, we might do it a little more efficiently, just because they're literally identical except for where changes are. The circuit court's kind of the same thing. Okay, do we need a roll call today?
Yes, Mr. Chairman. Representative Kinner.
Here in Sheridan.
Representative Larson. Here. Representative Olson.
Here.
Representative Schwartz.
Here.
Representative Summers.
Here.
Representative Walters.
Here.
Senator Agar.
Excused.
Senator Rue.
Excused, he'll be a little late this morning.
Senator Hicks.
Here.
Senator Kinski.
Here.
Co-Chairman Bebout.
Excused.
Chairman Nicholas.
Here. All right. Good morning, everybody. Welcome to day 2 of the Joint Appropriations Supplemental Budget Hearings. Today we have off the bat the Supreme Court, Judicial Conduct and Ethics, Attorney General, County and Prosecuting Attorneys, some legislation after lunch, district attorneys, and public defender. So it's a legal day. We're short a few folks on the, as the court may well know, Senator Bebout, Chairman Bebout is ill. I see that Drew Perkins is on. He's also having still some health issues, so he's kind of in and out as we move forward. Drew, if you're listening, I hope you have an opportunity to talk about us today. Your thoughts on the recommendations on the Chancery Court, because there'll be recommendations on there. So hopefully you'll be around for that, because we'd really like your feedback on it. But with that, let's get started. Supreme Court. Justice Davis, are you there? There we go. Welcome.
Thank you. Good morning, Mr. Chairman. Can you hear me all right?
Yes, sir.
All right. Members of the committee and newly selected members of the committee, I think there are some that will be attending. Thank you for an opportunity to address the judicial branch's supplemental budget. As I think everybody knows, I'm Mike Davis, and I have the honor of serving as Chief Justice for a little while longer. With me today is Justice Kate Fox, who will be the incoming Chief Justice in July of next year. She's been very involved with the Chancery Court, and maybe she'll be able to answer questions. In addition, we have the presidents of the District and Circuit Judge Conferences, Judge Catherine Wilking and Judge Brian Christensen, who are supposed to be with us. I don't see them, but that's probably by design. We also have with us and available to you our Court Administrator, Lily Sharp, our Deputy Court Administrator, Rhonda Munger. I heard Representative Summers say that we should have someone walk through the supplemental budget, and our Chief Fiscal Officer, Claire Smith, is prepared to do that. And we also have our Acting Chief Information Officer and General Counsel available. Mr. Chairman, I will keep my opening remarks brief. I know this committee has studied the supplemental budget and is famous for its ability to get you into the details. I do feel I would be remiss, however, if I did not talk about the unique mandate and workload of the judicial branch in these difficult times as that relates to the budget. We have seen communications from the Legislative Service Office asking for descriptions of programs that might be reduced or eliminated. And I just wanted to point out that the judicial branch does not have programs. It has cases. The judicial branch likewise has absolutely no control over the type or number of cases which are filed. The legislature creates crimes, which law enforcement investigates and the county and district attorneys prosecute. And the judicial branch has no control over the choices of criminal cases that are prosecuted, nor should it have. In addition, private citizens and organizations file civil actions as they need to protect their interests. Once a case is filed, the judicial branch has an obligation under the Wyoming and federal constitutions to provide speedy trials to defendants in criminal cases. In addition, our Constitution requires that the courts remain open to citizens who seek redress in civil matters. It specifically said all courts shall be open, and every person for an injury done to person, reputation, or property shall have justice administered without denial, sale, or delay. That's in Article 1, Section 8. Our rules also require that courts provide a resolution of cases which is just, speedy, and inexpensive. Finally, under our Code of Judicial Conduct, a judge who refuses to hear cases or does not hear and decide them in a timely manner is subject to sanctions, including removal from office. I would also comment that our branch is 92% personnel overall, including all three levels of the branch. We may be somewhat unique in our use of judicial workload studies for our trial courts. These are intended to and do tell us how many judges and clerks of circuit court are needed to dispose of the caseload. A weighted workload study is a statistical study done by an independent contractor, statistician who specializes in that kind of work. We often find those people through the National Center for State Courts, and they do that work for other states. Our trial judges record their time for a period of 2 or 3 months, and then the statistician determines how much time tasks that they do should take, whether they're being done in Cody or Sheridan or Cheyenne. Once our staff has that calculation, it can pull together the numbers of cases that we have and plug the weights in and determine if we have enough judges, and in the case of circuit courts, enough clerks. Eventually, we have to get a new statistical study as our workload changes due to legislation or technological changes. Kind of an example of that might be the statute that provides an immunity for self-defense, which is a change from prior law, and it requires sometimes a fairly lengthy hearing in the district courts. So that will add to the workload when the next study is done. If you're interested, the studies are on our website. They go back a number of years, and hopefully they show you that there's no fat in personnel. In fact, the pre-pandemic numbers show that we were 3 to 4 judges, district judges short. I also wanted to address what I think may be a common idea out there, and that is that perhaps the workload of the courts has slowed in the pandemic. Thanks to technology, that has not been true at any level. The Supreme Court IT staff had purchased and installed Microsoft Surface Hubs, which are just computers with a really big screen so they can be seen various locations in the courtroom. And they had been installed in most courtrooms before the pandemic. It had also obtained Microsoft Teams, which is just about like Zoom, although at the time we got it, it was considered to be more secure than Zoom, and I think maybe it still is today. This Teams process basically allows a judge to send out an invitation to a hearing, just like went out for this meeting, and attorneys and parties can join that by video or audio, by computer, or it can be done without an internet connection by landline or cellular phone. We were really ahead of the curve in terms of what other courts are doing because we had this. As I'll discuss, we didn't have all that we would like or all that we needed, but as late as the end of June, Colorado was still trying to get some technology in place. And we've had contacts from Florida, Minnesota, and Oregon, all interested in the technology we had. we were able to start remote hearings and operations almost immediately in the trial courts. I suspect some of the judges and court staff had to learn how to use that high-priced piece of equipment sitting in the corner when the need arose, but they've now done that and are using it. And then we were fortunate to receive CARES Act funding, which has allowed our small IT infrastructure staff to further upgrade the technology in almost all of the 70+ courtrooms around the state. These are changes related to the coronavirus, such as we shouldn't be sharing microphones, we shouldn't be passing around exhibits, we need more viewers to keep people separated. And I guess if you're curious about that, I'd suggest maybe you ask Judges Wilking or Christensen. I would point out that in these times, and again, this is a topic for the judges, everything probably moves more slowly. A judge can't just fill up a courtroom with litigants and lawyers and work through a long list of cases as we did in the past, for example, in Laramie County in the mass criminal sessions we have. Jury trials have also been an issue. It's one thing for any of us to say, well, I'm going to go get a haircut or go to a restaurant and have a sit-down meal. It's quite another to coerce citizens to come to court and provide service to our justice system. And so we had to proceed carefully, and the trial judges were doing jury trials with social distancing and various kind of protective measures. And I think the trial judges would tell you the response was good. And it generated what comes out of having trials, which is that you get settlements, you get plea agreements, and cases move along. However, jury trials are now largely suspended due to this recent surge, but there are plenty of other business that can be conducted, as the judges can explain to you. As for the Supreme Court, our case log has remained even because the district courts are moving their cases. Our workforce largely works from home now that we have a surge in cases. We were bringing them back, but then got hit with the higher numbers you're all seeing. We do have a virtual private network that's really fantastic and allows everyone to work from home, virtually everyone except for our security guy and our library guy, and they're in the building. And this has been true for a number of positions in the circuit and district courts, although particularly the circuit court clerks are not as able to work from home just because of the nature of their work. The Supreme Court started video arguments in May, and that's worked pretty well. It takes a lot of our small technical staff's time to educate the attorneys on the use of the software and then to check out their equipment. And they haven't gone perfectly. Imagine your sessions don't go perfectly either. There's internet issues and so forth. But the bottom line is that everybody who needed to be heard at the Supreme Court has been heard. And I guess I'm proud to say that our courts have remained open and in business despite the significant obstacles the pandemic has posed. And I suspect you would not find any other state that has done better. In fact, some states simply closed down for a period of time, and we never did. I would also like to put the judicial branch's budget in perspective. Our entire budget is less than 3% of the overall state budget, as you all know. At one point, there was discussion in the executive branch with Governor Gordon that perhaps they would have to go to 20% cuts in the executive branch. If you cut 20% of the small judicial branch budget, that would wipe out 16 entire court operating budgets. We don't have one extra court, much less 16. So the possibilities for reduction are small, and the consequences would be dire, if not catastrophic. But our branch has done what it can to reduce expenditures, and I can't say that those reductions will not impact our work, but we're getting by. As you'll see, our budget contains less funding and cuts and certainly doesn't ask for any more. And I'm going to want to ask Mr. Chairman Claire Smith to walk through the budget as is the committee's preference, but I did want to mention a couple of items because they are kind of on the policy front. One potential saving would be to delay full implementation of the Chancery Court in one of two ways. The Supreme Court has adopted rules for the Chancery Court as required by statute, and we're on track to meet statutory guidelines to do exactly what the legislature ordered. However, one solution to reduce expenditures would be for a select group of district judges who are skilled in resolving commercial disputes like those intended for the Chancery Court to decide those cases until things improve economically, using the Chancery Court rules to move them expeditiously. The judges who would do that would be selected by a combination of the district court and perhaps with approval of the Supreme Court. I think that would be up to the legislature. But we kind of know who's good at this because we have published opinions from the Supreme Court, and you can pretty much tell who's really comfortable with complex civil litigation and who's not so much. Those judges would temporarily use their own courtrooms and staff, and eventually we would hope the economy would improve and the Chancery Court could become a freestanding entity as the legislature envisioned and is provided by statute with a dedicated Chancery Court judge. The interim savings of this option would be $900,000 per biennium. It also would save the cost of building a courtroom for right now, but the funds to do that are in the executive branch, so it's not directly relevant to, I guess, our budget. And this option would require legislation. The other option would be to delay the Chancery Court completely until the economy improves and revenues increase. And the impact of that would be the cases that would have gone to the Chancery Court would be decided as they are now. They'd be filed in the district courts that had venue under the existing rules of civil procedure, and that would result in a biennial savings of $1,135,000. So about what 300,000 more savings than would be if the district judges did this. The downside is that there would be no entity called the Chancery Court for a while, and that was, I think, a big important point to the legislature to have this court to attract business to the state. There would be no specially assigned judges with proven complex commercial case experience, and there wouldn't be an expedited process under the Chancery Court rules. That would also require legislation to relieve the deadlines in the existing statute and push the whole thing back. Another option, which we're not nearly so excited about, would be to delay district court electronic filing. This committee recommended, and the legislature adopted, a $2 million appropriation for that. And in our estimation, it would be very unfortunate if we could not go forward with electronic filing. We have a very small IT staff, as you know, smaller than consultants tell us we need. They have managed over the last couple of years to upgrade the case management system. That's the piece of the system that acts like a file clerk and filing cabinet, keeps track of documents that are filed. They've done that in the circuit court, and now they can turn their full attention to the district courts. We used a select committee of attorneys who helped us pick out an extremely sophisticated e-filing system, which has been very well received in the states where it is used. That system is called File and Serve Express. We are just about to get the system under contract. We're taking our time with the contracting because we learned our lesson from 2010 when the contracts that were entered into for Y-User, which is our current case management system, were entered into, and we're almost there. We also have a little good news because the district court clerks, who are not judicial branch employees, but who are constitutionally the custodians of the records of district courts, were initially reluctant to have us begin rolling out electronic filing until we updated the case management system in all of the courts, all of the district courts, which would put it way back at the end. I believe they are now willing, however, to let us begin rolling the system out court by court. So let's say we get Laramie County rolled out on our case management system by the middle of next year or sometime early next year. Then after the clerks at the district court get the hang of that part of the system, we look forward to rolling out the electronic filing system. So court by court, we would start getting electronic filing as we go along. So in summary on that point, electronic filing has been too long delayed, and we are poised to get the job done with an excellent system that should serve us for a long time to come. And it would be tragic if we lost that momentum, but delaying the rollout of e-filing would save $2 million until you decided to authorize it again. The last option has to do with the Supreme Court electronic filing system and case management system called C-Track. I know the attorneys have probably used it. That system was rolled out in 2008 and it's worked very well. In fact, Wyoming was the first state to have it. It was designed for Wyoming, and it's now the most widely used appellate court system in the nation. Unfortunately, though our system has worked up to this point in time, it's seriously outdated and it needs to be replaced with a new system. It could fail. We were allotted $1,741,000 for the new system with this committee's recommendation, and we'd like to get it done. We could say, well, maybe it'll wait. Maybe we could wait. It's working right now. But if it breaks down, it probably can't be fixed without a great deal of expense. And it probably makes more sense to upgrade than to spend money on trying to fix a system that reaches the end of its life and then fails. I guess it would be kind of tragic to me if we have an appellate electronic filing system and we had to regress to a paper system, all until we could raise the funds for what is already budgeted. But that's an option, and one we wouldn't recommend. And with that, I would be happy to stand for questions. So I'd like to turn the budget review over to our CFO for more detail. And I also hope the committee can find some time for Judges Wilking and Christensen to address the operation of the district and circuit courts in greater detail. I think Ms. Smith planned to go through all of the budgets with the consent of those judges. So thank you for hearing me out, Mr. Chairman, members of the committee.
Chief Justice, is always a pleasure. Questions for the Chief Justice? Representative Summers.
Mr. Chairman, thank you. Chief Justice Davis, thank you. And, and particularly thank you for your words on our constitutional mandate. Justice Fox and I had this conversation during the summer. The public does not often understand your constitutional mandate. And I think and you're not, by who you are, you're not going to advocate about that. And I think it's important that both legislators and the public understand. Having said that, I propose this question to you. Certainly salaries for judges are set in statute, but salaries for staff are not. And so my question to you is one, could you handle a reduction of, let's say, 5% in staff salaries? So we just take a haircut on staff salaries. What would be the implications of that? Is it a feasible mechanism for a cut? And what would be the consequences of that? So Chief Justice, that's kind of a big picture item that I wanted to kind of quiz you about rather than Ms. Smith. So thank you.
Mr. Chairman, Representative Summers, that is a good question, and I can deal with the big picture side of that, I think. And Claire may actually have some numbers or ideas. And in addition, I think the circuit, Judge Christensen, who is a circuit court a judge and the president of their association, would know some practicalities. The majority of employees, I guess, in our system would tend to be maybe circuit court clerks plus Supreme Court staff, but we have far more circuit court clerks. I would just point out that they don't get paid very much. It's a pretty low amount that they receive. They do receive good benefits. And I think it would be tough to continue to attract good people. I think that's kind of true throughout the branch, that the folks that go to work for us do perform well and probably are desirable. We don't seem to have many people who choose to leave us that don't find good employment, usually at a better salary. We could work up those numbers if you like, Representative Summers. I don't believe we've done so. I know one of the things that probably drove us is the governor was talking about furloughs in the executive branch. And I think he wanted to start at $60,000 and up, and maybe that applied to pay cuts. We just don't have a lot of non-judge employees who are making over $60,000. And so that's an issue for us. And then, of course, the judges you mentioned, it's not only that there are statutory limitations on judges, but the Constitution of the state of Wyoming as to district judges and Supreme Court doesn't allow any change in compensation during the term of the judge, which extends to all the judges. So if you get one new district judge, then that is considered an expiration of a term. But those are protected by the Constitution, and then the circuit courts have a statute that provides the same thing. So you're correct, I think, in focusing on who could be whose salaries could be reduced, and I think it's a pretty small number that would be making over the 60,000. That seemed to be a cutoff. Sorry, I don't have any more detail for you, Representative Summers.
Mr. Chairman, just a quick follow-up, and Chief Justice, thank you for that. And if your people can work that up, that idea of a 5% cut, what would it impact? Who are the salaries? Not to say we'll do it, but there's always that discussion on, and particularly as you mentioned, 92% of your agency is really based in salaries, and I think you've done a good job of not bloating the rest of your budget. The IT thing, is IT throughout the state. You can't. It's just part of the new wave, right? So I do appreciate that. If you can give me some information on that, because we'll hear from other legislators on this issue as well. So I would just as soon get as much information as I can. Thank you.
Mr. Chairman, Representative Summers, we will do that. And I think you might want to continue that dialogue if you have time with Judge Christensen, and we'll have a little better sense of the circuit court situation than I do.
Representative Larson.
Thank you. Justice Davis, thank you. It's always a pleasure to be in your presence and listen to your comments. You pointed out in your document and then referenced again today that the judicial branch is 3% of our general fund budget. I was just curious if you knew how that compared nationwide, regional, or neighboring states, or is that low, high, in the ballpark?
Mr. Chairman, Representative Larson, I kind of suspect it's going to be low just by sheer numbers. I was on a conference with happened to be the Chief Justice of Texas. They have two Chief Justices in Texas, but the civil Chief Justice mentioned just casually they had 3,700 judges in Texas. And not to be outdone, the Chief Judge from New York said they had about 3,000. And of course, they have a bigger budget. I don't know how that all fits in, but we have a grand total of 53 judges from the circuit courts through the Supreme Court. But we could try to take a look at that. We have looked at some kinds of comparative things. I don't know if the bigger, the states with lots more judges get some economies of scale or what, but we could take a look at it. It's not always easy to get some kinds of information, but I think that might not be too difficult.
President Stith.
Mr. Chairman, thank you. Mr. Chief Justice, thank you so much for your presentation. I want to thank you for the investments you made in courtroom technology before the pandemic. I think it made a big difference in making the court system function during the pandemic. Thank you for that. I did have a question. It's my understanding that the Supreme Court did not apply to the governor for CARES Act funding to implement the electronic filing system this year. If there were a second round of CARES Act funding from the federal government that were made available to the states, would the Supreme Court be willing to apply to the governor's office for CARES Act funding for this implementing the electronic filing this next go around, if there is one?
Mr. Chairman, Representative Stith, I think a big roadblock to us to doing that would be that the CARES Act does not allow funding for anything that's budgeted. And we have a budget for electronic filing, one. And the other roadblock would be they put time limits on this, and it takes time to get things rolled out and put in place. And then the third problem I guess that might come up is the process we went through is, I don't know how it fits with separation of powers, but nobody's complaining when there's money available. But the governor's office made decisions about the funds, and the Attorney General's office conducted a review of the things that we had asked for. And by and large, they approved them. But there were some things the Attorney General's office said, this isn't really COVID related, and did not. We did not, as you point out, apply for funds to address electronic filing. And perhaps there's an argument to be made that if we had electronic filing, we're now limping along with email filing, which is a poor substitute. That would be a way of reducing traffic and handling of paper with the concomitant risks of disease. But I think we just would run into the budgeting and time problems. But we would be willing if it was legal, I guess is the bottom line. We would, any money we can get our hands on legitimately and not get ourselves in trouble with the federal government is welcome.
Senator Kinski.
I'll wait for the budget presentation.
Senator Hicks, Mr. Co-Chair.
Yeah, Chief Justice Davis, a question I have on getting back to the 92% is personnel. One of the areas that I've got a question for you. So under Article 5, Section 4 in the Constitution, subsection A, it says the Supreme Court of the state shall consist of not less than 3, no more than 5 justices as determined by the legislature. If the legislature was so inclined to reduce the number of justices from 5 now down to 3, as a budget saving, approximately $450,000 to $500,000 a year out of the court's budget, how would you guys go about determining which 2 justices would be eliminated?
I think there's some folks that'd like to see me out the door, and I'm getting there relatively soon. But, you know, I did a little research on this, maybe to just provide a little background. Mr. Chairman, Senator Hicks, as you said, the Constitution in 1890 set the number of Supreme Court justices at 3, and then about 1957 allowed them to increase to 4. And that actually went into effect in 1961. And it was a terrible idea because, as you all know, being legislatures, you get ties. So then in 71, another amendment did do exactly as you said. I guess I have to believe that the reason for the increase was to assure that the court had enough justices to issue decisions promptly in the face of rising numbers of cases back in the 70s. And those were different times. I mean, there was no circuit court for the Supreme Court to administer. Those were the days of the justices of the peace courts. JPs were selected by the counties. There was no effort to get a statewide electronic case management system. They didn't have computers. No requirements for chancery court. Lots more crimes and remedies available. When I started practicing law, they really didn't have an equivalent of the domestic violence abuse protection statutes that we have now. So, I mean, I don't know how it would work. We did do a little looking at other states to see what their staffing is. No state has a Supreme Court with less than 5 justices. None at all. The majority have 7 to 9. And most of those states, the vast majority, have an intermediate court of appeal, like Colorado or Nebraska. So that means that a lot of the cases that we hear, because we have no intermediate court of appeal, are winnowed out by the intermediate court, and then the Supreme Court doesn't have to take them if they don't pose a question of law. Wyoming doesn't need an intermediate court of appeal, but the Supreme Court, I think it has what it needs to do in performing both of those roles. But to get to your question, how would you choose? Of course, we have the constitutional provision says you can't reduce the compensation of a Supreme Court justice during his term, and that would include all the justices of that kind, the way the Constitution's written. And the next one out is me in January of 2022. I don't know how you could do that if it was done. And I don't know how you would choose, because these justices have terms. And so I don't know how it would be. We certainly, contrary to the trend, what I'm hearing about these days is not appellate court size reduction. Instead, it's court packing is the talk of the day.
We're going to unpack.
Yeah, I think we probably just about right for our caseload. And at times maybe a little overrun. At times just caseloads fluctuate. Sometimes it's a bit about right on balance.
Further questions?
I don't know.
Any further questions? Any comments or questions to the Chief Justice on the Chancery Court issue?
Senator Nicholas, this is Senator Perkins.
Oh, welcome, Senator Perkins. Please
Thank you.
proceed.
Well, I think Justice Fox is around, and I think that's one of the reasons that she's here. So I think we'll just, I'm more than happy just to have that discussion when Justice Fox is up and in front of the committee.
Mr. Chairman, President Perkins, Justice Fox did not necessarily intend to speak. She didn't have any particular range of topics, but she's available at the chair's convenience if there are questions.
Sure. Well, I misunderstood then, Mr. Chairman. Mr. Chairman, I did hear you earlier, and if this was the appropriate time to have that discussion, happy to do that. Justice Fox and I have spoken a couple times during the interim with regard to the Chancery Court, and we've discussed both of these, the recommendations that she has. In looking at the budget, my preference would be that, it not be delayed, but recognizing the times that we're in and trying to be responsive to that, my preference is to do option B, which is to temporarily fold the Chancery Court function into the district courts. We do have a number of district court judges that are interested in serving on this panel. Our initial legislation when we passed the Chancery Court does provide for the use of sitting or retired Supreme Court justices or district court judges that meet the expertise requirements in the statute. So it does require a modest legislative directive to extend the time that those folks can serve and here or sit as a Chancery Court. But excuse me, in recognizing those issues and looking at, difference between the two options is really just about $235,000. And I do think it's important to move forward with this, that for $235,000, essentially, if we can move forward in the district and have the district courts do that, I think it'll do two things. One, it'll help us continue to move forward. Two, it'll actually help us work out the kinks as we move forward in this court. So when we actually stand it on its own, we'll have more experience and we'll be, I think, start to have the expertise about how to run that court. It'll help us identify and know how to do that. And three, I think that there were some district court judges that wanted to play anyway. They enjoy those types of cases. And so I think I have no problem with the very good, the district court judges that hear and deal with complex civil litigation generally do a very good job. Those that enjoy it, understand it, and have the experience before they became judges. The other thing that I would remind or just bring up, Mr. Chairman, is that one of the reasons that the Chancery Court became important to the legislature, and I think why it passed resoundingly when we brought that legislation, was the recognition that it wasn't a comment on our judiciary, but there was a perception abroad as we were trying to develop and expand the economy of the state of Wyoming, that our judiciary did lack some of the expertise. And also the other thing was simply, we needed to be faster. It needed to be more timely, a lot more, the Chancery Court in Delaware resolves most of their cases within 90 days. Cases that aren't resolved within 90 days, the judges have to start writing opinions to the head Chancery Court judge about why they're not done. And so it was to move that forward. That's been received very well, I think, across. I think that as we look at where Wyoming is and where it's headed, that our efforts to continue to diversify and expand our economy are all the more important now than they have, as we move forward. And so I think we can save quite a bit of money by delaying by folding this in, beginning and moving it forward with what we have. And I think that it's important that we would do that. And so that would be my preference. And I'd be interested, Judge Davis, Chief Justice, Mr. Chief Justice, if if what your comments are, your thoughts are with respect to my comments. Thank you.
Yes, and we also have Justice Fox, if she would like to comment on that as well. So please proceed, either one of you.
I guess, Mr. Chairman, President Perkins, I guess I would defer to Justice Fox if she's here. If she's not, I'll take a stab at it.
She's here.
Here I am. Thank you, Mr. Chairman. Senator Perkins. Actually, I think Senator Perkins summarized the situation very well, and we would be happy to proceed with the Chancery Court plan under this sort of modified approach. And there are a number of advantages to it that I won't repeat. I think Senator Perkins has explained them. It does put a little extra burden on the district court judges, but I think that they're willing to undertake that as an effort to help with our budget situation. It doesn't take much of a legislative change. It's my understanding that the Blockchain Task Force has come up with a bill that just postpones the full implementation of Chancery Court. In the current statute, that is supposed to be March 1st of 2022. And if the bill that the Blockchain Task Force has put forward just pushes that out to, I think, 2026. I believe that Representative Greer had proposed that amendment. So that's the legislative change that would be necessary to continue the transitional period during which district court judges handle this work a few more years.
Justice Fox, how does that impact the Casper office building and how it's built out?
Mr. Chairman, I don't know that it does, and I think Representative Walters has some information on that.
All right.
The money for the Chancery Court in the Casper office building is, as the chief mentioned, it's in the executive branch budget, not our budget. So we haven't really included any discussion of that. I think that there's a sense, and I'll let Representative Walters explain this further, that they might as well go ahead and build it as long as they're at it. But we're sort of not taking a position on that at this time. It won't be necessary until 2026 if the amendment to the Chancery Court bill goes through.
Well, it could be necessary if you have district judges, say, from far corners of the state, if they would go and conduct the trial in Casper, because the locality was also an important issue on where the trials occur. So,
Mr. Chairman, that's right. It could be used.
Representative Walters.
Thank you, Mr. Chairman. To answer the question on the build out in the Casper office building, it's approximately $775,000, give or take a little bit in that neighborhood. And Justice Fox is correct. The construction appropriation has been held in various CapCon bills that have not made it through the last session or been taken up in a special session. However, there is funding available in the existing budget for that office building project to cover the cost of doing the build out for the Chancery Court in the building. I think Justice Fox makes a good point that if it's not going to be used for another 6 years, 5 years until 2026, the build out may be a little bit premature. Chairman Nicholas, you're correct. The location of the court was always a big issue, and having it centrally located in the state, as other states have experienced, allowed that to be a more successful court experience, and the court was more successful if it was centrally located and had a permanent home, was what was testified as this bill proceeded through the legislature. I had a good visit with Representative Greer this summer on this exact topic. The original intent was to have this carried out by the district courts throughout the state. The interesting thing that I would note is once it was passed and the district courts were polled, would they be interested? They all felt they were too busy and couldn't handle it. And that is why a standalone courtroom and a standalone setup was then contemplated. And so I appreciate the district courts now being ready to take on these tasks. I just hope that their current caseload doesn't prevent them from getting to these in an expeditious manner as was envisioned. So like I said, on the construction side, delaying the construction would probably take that $775,000 to closer to $1 million to build it out if it was delayed. And the main reason for that is it's easy to do it while all of the tradesmen are on site and it's part of the existing project. To bring those tradesmen back in and do it at a later date just costs a lot more money. So it's our preference and in working with the court what we want to do to proceed, but that's a little more information on that front.
Great. Further questions for either Justice Davis or Justice Fox? Representative Olson.
Thank you, Mr. Chairman. I just wanted to clarify because Justice Fox had brought up the legislation, just so this committee is fully informed. We do have the Select Committee on Blockchain does have a bill. It is very simple. It's a page and it literally changes that vacancy filling date. I can't remember if it ended with 2024 or 2026, but I do know the bill passed out of the committee as a sponsored bill. So at any rate, that date can be amended however we want it to be. But the point is that that appears to be the easiest and most simplistic fix. So just so the committee's aware that bill it's out and hopping.
So can the blockchain committee sponsor bills or does that go through someplace else?
Mr. Chairman, we can. When we were a task force, we could not, but then we became a statutory select committee. So we can sponsor all legislation that's not Title 13 legislation, which is banking legislation, and that has to go to minerals per the statute. Otherwise, we sponsor our own bills now.
Senator Kinski.
I decided I'm going to hold on this one too. I'm really anxious to hear from Judge Wilking and Judge Christensen, so I'm not going to hold us up. I'm sorry, Mr. Chairman.
All right. Any further questions? All right. Thanks a lot. So let's, Claire, can we jump into the budget and off we go?
Thank you, Mr. Chairman, Mr. Co-Chair, and members of the committee. I'm Claire Smith. I'm the Chief Fiscal Officer for the Supreme Court. For those new members, I'd like to point out that the judicial branch budget doesn't follow the exact same format as the executive branch, but we do try to keep it very similar. Our budget book covers the Supreme Court, which includes circuit courts throughout the state, as well as all the district courts. District courts are free of fiscal and administrative control from the Supreme Court. However, they don't have a dedicated fiscal person to handle their budgets for them. My department within the Supreme Court assists them with their accounting and managing their budgets, but the district judges are 100% responsible for their own budgets. I'm presenting their budgets to you simply because I have access to all their fiscal data and I do the compilation of the budgets on their behalf. So the first few pages of the budget book summarize what Chief Justice Davis just spoke about. We've implemented cuts in every division of our organization other than the Judicial Nominating Commission. That budget is so small that any cuts would be insignificant. So if you'd like to turn to page SC8, we'll jump right into the first unit. So this is our administration unit, which covers the bulk of our personnel and operating costs. We've implemented cuts in the amount of approximately $470,000, including the elimination of one position. As we began discussions this summer on budget cuts, we too implemented a hiring freeze with a waiver request process to fill critical positions. Through that effort, we identified a position in the Supreme Court Clerk of Court's office that we were able to eliminate through redistribution of duties to other staff members. Additional cuts in this division include either the elimination or reduction of general operating costs such as membership, subscriptions, supplies, and things of that nature. You'll see at the end of the narrative on page SC8 that the court recommends approval of these reductions. Are there any questions on this unit?
Senator Kinski.
So Claire, on page SC9, is that the detail on the particular unit?
Yes, yes, Mr. Chairman.
And so that one position accounted for $250,000 in payroll. Am I reading that right?
Mr. Chairman, Senator Kinski, that's correct. Between salary and benefits for a biennium, yes.
Okay, thank you.
Mr. Chairman.
Representative Summers.
Mr. Chairman, thank you. And Claire, you know, this is just me being picky on these budgets, and I know that you'll outlive me on this process, but you know, the governor's side, the main agencies, the way they present them and the write-up they have on their reductions or their requests are much more thorough. So when I go in here on your 200 series and your 207, dues and licensing, and you're cutting 140,000, I'm assuming that is something specific, but we don't know that by the write-up in this budget. And so, you know, if you can get not now, but if you can get kind of a little paper for whoever has this on the floor, you know, that 140,000 is a very large sum. So one would assume you're getting rid of a due or a subscription to some entity. But if you can kind of go get a paper on what your reductions are actually doing, it helps us understand the budget. And then I'm going to throw back at you what I threw at the Chief Justice, and that is, you know, if we were to trim 5% of the salaries of staff, what would that look like? And is that actually a feasible option? Based upon contracts, can we reduce that, or would it require you to? Can you reduce salaries, or if we reduced your 100 series, would it require you to eliminate personnel? So, and you don't have to answer that now, but those are questions I have.
Mr. Chairman, Representative Summers, I will certainly get that information to you. And just at a very high level, that we are eliminating one main subscription or dues to the National Center of State Courts. It's very unfortunate. It is a helpful organization, but as you see, we don't have a lot of places where we can cut. So I will get you a little bit more detail as you've requested on both of those questions.
Okay, please proceed.
Okay, if you'll turn to page SC10, so this is our Chancery Court unit. And as Chief Justice Davis noted, we have several options for what we can do. At the time that we created this budget document, we assumed Chancery Court would move forward as directed by statute, and we developed a budget reduction plan based on that assumption. After hearing the discussion that took place just a few minutes ago, it sounds like the general consensus is that option B that we've laid out is more favorable, where the district judges would take on the Chancery Court functions. So having said that, and based on the conversations that just took place, Mr. Chairman, would you like me to walk through what we have presented as cuts under this scenario of moving Chancery Court forward as is in statute now?
You know, I think, thank you, Claire. I think we've read the options, and I just want to re-emphasize, I think what Senator Perkins described is he would prefer to do nothing, but if we do something, option B would be preferable. And so with that, I don't think we need to run through those other options. And basically the Chief Justice briefly touched on them, so go ahead.
Okay, thanks, Mr. Chairman. So basically with option B, I'll need to get you I'll need to get LSO at some point a more detailed list of where the cuts happen by object code, and I can certainly do that.
That would be
based
great.
on that assumption. Okay. Okay, then having said that, let's flip to page SC12, our next unit, and this is the law library. Total reductions in this unit are $90,000. There's $33,000 of one-time funds included in that. Part of the cuts will be reductions to subscriptions and publications based on review of usage over the last few years. And given the budget issues the state is facing, we'll be more aggressive in what we eliminate than we have been in the past. We had an exception request in this unit for updates to the Judicial Learning Center exhibits. We're not going to move forward with those. We're not sure when the pandemic will lighten up enough for us to reopen the Judicial Learning Center to the public. So these are costs we don't need to do now. We can reconsider next year whether we need to do them or not.
Claire, sorry to interrupt. What was the anticipated update? Because I mean, it's likely that that will be open in April or May.
Mr. Chairman, we have one exhibit that we were wanting to upgrade to a more digital format. It's just a static exhibit right now, and something else that's got some outdated information on it that we wanted to get with up to date with current case law.
And does the 33,000, is that a bid amount, or how did you come up with the number?
Yes, that is based on the vendor that we use and the costs that we've incurred in the past based on upgrades that we've done. So when the time comes to do the work, of course, we will put that out to, we'll get a couple of quotes on it, but there is one primary vendor that has done all the work on those exhibits and created.
So if you put that out to bid, my guess is the work wouldn't happen until you could do the work now and it would be ready for opening in May. Would that be a fair assumption?
Mr. Chairman, that is correct. I can't say exactly how long it would take to do that exhibit. I don't imagine it would take that long. So yes, if we wanted to move forward with it, we could probably get it done by April.
Okay,
that's when
please
we're going to
proceed.
reopen.
Thank you.
Thank you, Mr. Chairman. Let's see. Just a note, the library has remained open, or I'm sorry, has continued to respond to research requests while it has been closed. It provides materials either for pickup or mail delivery. So I just wanted to point that out, that the law library is still serving its purpose, even though things have been closed down through this pandemic.
So Claire, I do have a question. You have 4 employees, one of which is, I believe, part-time in the library. Are they fully engaged? Are they working full-time? I know that when I go to the library, which is not near often enough, but it's almost always empty, and very seldom is someone even at the front desk when I go there. So I'm just curious what they're doing, how busy they are. Do you monitor that? Is this a location where you could drop one personnel? I'd rather have library than I would have library personnel, just to have the information available. I'm just curious what the court's feeling is on that.
Mr. Chairman, the law librarian is still working full-time. This has actually been a good opportunity for him to start going through our materials, weeding out the old stuff, really concentrating on that research that we need to do to figure out what subscriptions and materials we can reduce in budget cuts. So yes, he is still working. The part-time person does still come in to help with the product that is still arriving and getting things shelved as needed. The other 2 employees, so over time, all of our employees wear more than one hat. And so the other 2 that are in that division are not doing primarily library work. They are helping in a lot of other areas. And in fact, this is something we've talked about. You'll probably see in our next biennial budget that we will use the chief's flex authority to put those positions probably within the administration unit where it makes more sense. So that when you're looking at the library, you'll be able to look at the costs that really truly are library specific, because we have some personnel doing things other than library work. Does that answer that question?
Yeah, thank you. And I know that the last time I was there, someone was rearranging all the books and I had a hard time finding a few things.
Oh, sorry.
Okay, please proceed.
Okay. So our next unit, our next division starts on page SC 14. This is the Circuit Court Division. While the COVID-19 pandemic has hit the country pretty hard, there has been somewhat of a silver lining that results in a number of areas where circuit court budgets can be cut. The courtroom technology that the branch has been upgrading to over the last few years allowed courts to adapt to a socially distant working environment with relatively little pain. And in addition, the infusion of CARES Act funds to enhance and complete the technology upgrades gives judges the ability to conduct many hearings remotely. This means judges can now assist each other remotely when conflicts or scheduling of problems arise. So the courts are able to reduce travel costs and use of contract magistrates, and that's a total cut of about $150,000. Other cuts we've made in each judicial district on pages SC 15 through SC 23 include reductions in various operating costs, such as subscriptions, supplies, and communications. It varies by court. The total cuts of this nature are approximately $200,000, and they're spread through all the circuit courts.
So I have a couple questions, Claire, and I think if Brian is around, Brian, you might want to answer some of these. So where are we? How far along are we in these upgrades? And my questions are, number one, I've seen situations where circuit courts refuse or require defendants and defendants counsel to be present, which means that, and if it's a traffic ticket or some other thing, they've got to go from Cheyenne to Rock Springs just to appear and be part of it. And to me, it's a mechanism, or it's a tool that I think no longer should prevail. And I'm just curious what the courts, if they have rules or policies on that, because it's extremely expensive for clients and counsel to do that. And I'm just curious what the policies, or if they're changed, or if that, with the upgrades, if that's still going to be an issue, and what the proper, if you make a motion to the court to appear telephonically or via video and it's denied, then we're not using the upgrades of the benefits that we have. And I just wonder what the court's position is on something like that in general.
Mr. Chairman, let me answer your first question, and then we'll turn it over to Judge Christensen for some more of that detail. Your first question was how far we are on the upgrade. We have 9 courtrooms left to go throughout 5 different courthouses. Our vendor that we're using for that is working very aggressively to try to meet the CARES Act deadline of December 30th. And we anticipate we will have all of those upgrades done by the end of the year. So with that, if I can turn it over to Judge Christensen to answer your other questions.
Hello, Brian, how are you?
Good, thank you, Mr. Chairman. Members of the committee, my name is Brian Christensen, Circuit Court Judge in the Trumbull County and President of the Circuit Court Conference of Judges. Yes, and now with the full implementation, of course, with the technology, but we need to know about those things. If you're talking about traffic ticket, we don't always know about those traffic tickets, and people drive over and appear, or they have to let us know ahead of time. As far as I know, all the courts are accepting arraignments and are even doing some bench trials based upon the waiver, the temporary change in rules that our court rules allow us for doing those type of things in circuit court for all hearings. And, we have judges that are sitting for arraignments, like Judge Castano's doing arraignments for Judge Prokos in Sweetwater County when he's sitting in Weston or Crook County. I was able to handle a DUI conflict case by technology for all pretrial and sentencing hearings in Carbon County. And this is happening throughout the state. So we're seeing more and more of that. And, but again, we'd have to know ahead of time. Just calling into the court on the time you're supposed to be appearing before a court may be of an issue to be able to do that because of certain people calling in or invites on video technology. Phones may already be tied up on the number of cases if they're stacked. So there are some limitations, but they can be resolved, again, if we know about them in advance.
Yeah, so, Brian, to me, it's a matter of judicial economy, and we have a mandate to make the courts of law as inexpensive and as reasonable as possible. And so what it seems to me that you as circuit courts in general should establish protocols so that the lawyers know that if they file and do the appropriate communication with your clerks and with the court, that it's not unreasonable that the courts will accommodate them to do anything that will save everyone money, and you still can get a modicum of justice and do a good job virtually, just because that's the wave of the future. But it's just I know that I had numerous folks who complain about this issue to me. And so I know that it's still ongoing. And so I just bring it to your attention.
And thank you, Mr. Chairman, and we'll continue discussing that, making sure, but the temporary rules we have in place do allow that.
Mr. Chairman?
Ahead of
yeah, Senator Perkins.
Thank you. Judge Christensen, Drew Perkins, thanks for being here today. A quick question for you. I mean, with the pandemic and the rules, isn't basically the default now is that you appear by technology or virtually as opposed to in person? Has that now become the rule rather than the exception?
Thank you, President Perkins and Chairman Nicholas. It's becoming more and more as the judges become acclimated with their technology that is the case. If I had stacked preliminary hearings a week ago, or must have been a week ago, I had 6 or 7 attorneys and all but one appeared on video. So we were able to handle those preliminary hearings through video technology. One was in person as an individual was in jail, and they needed to have a conversation with them. But those things can also be addressed if we know ahead of time. We can do basically sidebars through technology with nobody else hearing. So yeah, it's becoming more and more the norm as we become more and more acclimated and accepting of our new technology.
Right, Mr. Chairman, if I may,
please.
And Judge Christensen, which thank you for that, and which kind of leads to my question: Do we anticipate, or are the judges or the Supreme Court, are they considering potential rule changes now that we have a kind of a new normal, that actually maybe the default is that we appear virtually unless the court or the parties request appearance in person? Is anybody looking at those types of things? Because that seems about where we are now. Thanks. Thank you, Judge.
Thank you, President Perkins and Chairman Nicholas. I'm not sure we've gone that far that it's a requirement, but it is accepted in the temporary rules, and we are reviewing those rules to see what we would like to keep in place permanently in rule changes. And I think you will see more and more probably heading towards that, where more and more hearings are held virtually. There is still requirements of due process for being able to confront your witness in a trial. Those things would still at this point would require trial cases to allow defendants and witnesses, unless waived by the defense in a criminal case, to appear in person. Civil cases can be done upon motion and justification. So there are ways of doing that, but I think we are headed to at least non-trial and non-hearings that need to be held in person to be held virtually by video or audio technology.
Representative Steve.
Mr. Chairman, Judge Christensen, if the legislature wanted to eliminate circuit court magistrate positions to save money, would that require a statutory change in your view?
Thank you, Representative Stith. Chairman Nicholas, yes, it would. The statutes are set up now, if you're talking about full-time benefit magistrates, that the only way to review that position is upon vacancy of that position, or by the local judges in those districts in the judicial district vacating those positions by a majority vote. So it is, I would say, maybe time to look at that and have the Supreme Court be able to review those positions on when they come up for retention, maybe, or some other mechanism. But that could be a possibility as well.
Representative Summers.
Mr. Chairman, thank you. Judge Christensen, thank you for being in front of us and for all you guys do out there. We do appreciate it, even though we ask hard questions sometimes. So my question is we go back to your budget, you guys have taken a smaller haircut than anybody else within the courts even. And as I look, as not being a lawyer, not understanding the system, and I look at various districts having took let's say different cuts or no cuts and have different values associated with them. I assume some of that is like the scale of personnel. So somebody's been in place 12 years versus 5 years or whatever. So you'd have different pay scales based upon seniority or something. Could you speak a little bit so at least I can understand why there's so much difference between each circuit court? And then as we look at whether we could do a haircut to salaries of those people below your level, what would that do? What, if we did something like that, what would be the consequences of that? So differences in courts, why do we see such a differences in cost of courts? And then why can't we do a salary decrease on certain people?
Thank you, Representative Summers, Mr. Chairman. Having heard the discussion earlier, maybe I'll go to those first on the 5% potential reduction in staff salaries. Those staff that we have are based on our workload studies. When I started in my appointment 7 years ago, because of efficiencies and new software and new technologies over the years, Natrona County has lost 2 clerk positions. During this pandemic, our clerks were designated as essential personnel. Their workload didn't decrease, and we've been very lucky statewide in not having an outbreak of COVID in our clerk offices. And I think that just goes to the responsibility of the clerks that they've taken upon themselves to how serious they take their jobs. They work this whole time, and we hope they are recognized for their extraordinary work and not hit with a reduction. The impact, obviously, the circuit court judges feel, of course, that their clerks are underpaid, but the impacts of hiring and retaining qualified clerks, it would reduce our ability to do the functions for the state of Wyoming. The judiciary is not another state agency, but a separate branch of government with those constitutional duties that we've talked about before, and we undertake those seriously and without excess based upon those workload studies. We do not operate programs, but ensure the people of Wyoming have a place to address those protected rights and handle conflicts in the civil forum. And the judiciary must deal with every criminal and civil case filed in our individual courts. We can't just set quotas or deny service. What is filed must be dealt with. And to your point, why are some courts busier? I think for here in Natrona County, it's an easy answer having to do with our medical facilities and the collections cases that happen here. If you look at our workload studies, our collection numbers are way above anybody else in the state, and makes for a lot more activity and work on filing from collection agencies and attorneys, as well as garnishments and collection of funds through the courts to handle all those cases. So there are some specific things unique to every court, and I-80 corridor, I-25, I-90, having to do I-80 with a lot more with traffic cases than the other courts. So there are instances where location does mean certain increases in workload in cases that a court may see. Because of technology and because we've been getting more and more used to it, like I said before, we were able to handle hearings for other judges around the state. And that's why we've been able to all but eliminate some negligible times we do need magistrates, but we're getting to where we want to try to eliminate the use of part-time magistrates due to our being able to cover for one another, sitting in our own courts for a court that has a judge going on vacation. And I've noticed on our thread emails when a judge says, I want to go elk hunting, as anybody can, they cover these essential hearings based upon my initials, based on arrests, forcible entry and detainers, small claims, protection orders. Can those be handled by other judges out there? And overwhelmingly, we find judges are willing to cover, and they get that coordinated with their chief clerks. This adds more work for the chief clerks and to get that done. But it is getting done. And as Chairman Nicholas noted, that case I had in Rawlins, my attorneys were from Laramie and from Rawlins, and I was sitting here in Natrona County, and we were able to do almost everything pre-trial, or we did do everything pre-trial on video technology. So I think, as President Perkins noted, we'll be seeing more of that and headed towards that norm. But there are instances where you do still need to hold in-person hearings. And I'm not sure I got all that, but I tried to shotgun that, Representative Summers.
Mr. Chairman, thank you. No, that got it. It's basically the difference between districts is simply the caseload and how much staff you have to handle that caseload based upon those studies that occur on caseload studies and what we've appropriated. Thank you.
Mr. Chairman?
Go ahead.
Thank you, Mr. Chairman. Senator Christensen, as you go down through there, each district, do you know what the range of judges per district is? I mean, the low and the high between the 9 districts, as far as the circuit court goes?
Yes, President Perkins, Chairman Nicholas, if you're talking about how many judges are in a specific judicial district and circuit court, in Sheridan, Johnson County, there's one circuit court judge, but
court judges, yes.
Yeah, there is a full-time benefit magistrate who is necessary to assist up there in Johnson County. In the 9th district, having to do with Fremont, Sublet Park, there are 4 circuit court judges. And having the counties that have circuit court judges that sit multiple judges in the same courthouse, Natrona 3, Laramie County 3, Campbell County 2, Sweetwater 2, but again, up in Campbell County, Judge Castano from Crook and Weston is able to assist them in their workload in Campbell County. And I think there's also 4 in the 3rd district, so that'd be 2 in Sweetwater, and Uinta and Lincoln County would be in that district. And pretty soon I'll list them all if I keep going, so I'll stop there.
Further questions? All right, Claire, we're back on.
Thank you, Mr. Chairman. And one thing I will provide some additional information that I think will add a little bit more clarification to both Representative Summers and Senator Perkins' questions. It's not obvious in our budget book, but there are a different number of courts and judges within each judicial district. So I'll provide that information for you. I think it'll help with both of those questions that were just asked.
Yeah, so Claire, I just took some notes that I think it would be useful to do a breakdown of just every position throughout the circuit court and district court district court, we kind of know, but the circuit courts, it would. And I presume that they're all on the same salaries or salary basis, but we would also salaries by district and person.
Okay, Mr. Chairman, I'll do that. Okay, so we had one other cut to circuit courts, and this touches on Representative Siss' question. We did have 2 vacant employee magistrate positions. They've been vacant a little while, so we have eliminated those. We've also made some cuts to the special units within this division. Starting on page SC 24, you'll see we completely wiped out the special circuit magistrate budget. So this was money set aside for emergency situations when circuit court budgets didn't have magistrate funds available. So we've completely eliminated that. On page SC 25, we reduced our circuit court equipment budget by $40,000.
So Claire, by the way, could you, when you do the breakdown of positions, include all what existing magistrates are out there? And if there are terms or appointments for that, when those terms may expire. And I don't know if you monitor how much work a magistrate does in a particular district, but that would be interesting to know if you do.
Mr. Chairman.
Representative Summers.
Mr. Chairman, Claire, on this particular budget that we're on now on equipment, you know, I've looked at it and I've wondered, what are the impacts if we cut this entire piece of the budget? So you might, you know, there's some stuff there. It's not a lot of dollars. I'm assuming that it would be compensated for somewhere else, but I would like to know the impact of that entire budget line went away.
So what line item is that, Representative Summers?
Mr. Chairman, that's the equipment on circuit courts. It's only started out as only 104,000. They cut 40,000. There's 60,000 left. I'm really wondering how much, you know, whether there's room in there just to get rid of that.
So part of that, I think you have to understand there's kind of an unspoken rule of some sorts, Claire, and you might describe that on what counties have to pay for and what the courts have to pay for. And they've kind of drawn up a general understanding of what that is. And so I think that has to be taken into consideration, and then what equipment we're talking about, Claire. So go ahead, please proceed.
Okay, Mr. Chairman, this budget is used for some of the costs that are common to all of the courts. So specifically, the equipment rental has typically been postage meter leases and copier leases. We have found over time that it's more cost efficient for courts to purchase copiers outright, and then they use them until they just don't run anymore, which is usually quite a few more years than a lease lasts. So that's why we're able to eliminate $40,000 from this right off the bat. If we were to eliminate the entire budget, it would just mean that those costs, for instance, the postage meter leases, would be absorbed within each individual court's budget. And I just have to do a little bit of analysis whether how much room those courts have to absorb the cost that way. But it's definitely something I'll look at, and I'll get back to you with more information on.
Mr. Chairman.
Please.
Claire, Mr. Chairman, Claire, if we could go back to that emergency magistrate budget that you're removing. I was just curious, or the special court magistrates, can you tell us, do we know when the last time that was used? Was that something that was used very often, or was it just there history-wise, please?
Mr. Chairman, Representative Larson, that has not been used much at all. It's just been kind of a safety net if needed. I believe in the last biennium, we didn't use any of it at all. If we did, it was only in the hundreds of dollars.
Thank you.
Claire, where does the money go if it's not used? Is it recirculated or is it reverted? What happens?
It's reverted.
Thank you.
Okay, so Mr. Chairman, moving on, still within the circuit Court Division. We've also made some cuts on page SC 26, some operational cuts to our internal audit function.
So as we, members, so we've just gone, as we're scrolling down through the various circuit courts, if there are any specific questions on, say, the Fourth Circuit courts or pages that we've jumped, please jump in here. Okay, go ahead, Claire.
Mr. Chairman, in summary, the total cuts to the Circuit Court Division equal approximately $600,000. So the court recommends approval of all these reductions, which are also supported by the Circuit Court Conference judges.
Mr. Chairman.
Go ahead.
Mr. Chairman, thank you. And Claire, back on the examination of courts, and I look at that at the salary there, you know, if you could provide me a little more information on what type of individual that is, right, and what their qualifications are, and then what their yearly salary is. I'd assume it's divide that by 4, and you kind of have that number. You kind of have it, and salary versus benefits. Just I kind of want to understand what that position really is, a little more about it.
Mr. Chairman, Representative Summers, I will do that, but just for a high-level answer at this point, we do have a CPA in that position. This actually has 2 positions in it. So the CPA who is actually doing the audits, and then we have a fiscal analyst who helps the circuit courts with all of their bookkeeping kinds of issues. So I will provide you those details.
Okay, further questions? Please proceed.
On page SC 27, we have our general fund court technology unit. So this is another one that Chief Justice Davis talked about, where we have some options on what we can do. So the cuts that we've already made within this unit they include elimination of contracts and reductions in support and maintenance, ongoing cuts of about $340,000. We have a couple of options that Chief Justice Davis touched on. Option A is to delay the replacement of the appellate case management system. As a reminder, this is a one-time general fund appropriation. We received a $1.7 million to replace this system. It's getting
Claire,
close.
excuse me, could you remind me, the municipal court management system, is that the tie-in where we collect certain fees if they hook up to it? Remind me what that is.
That is yes, the legacy system that the municipal courts, the municipalities are using. It is their case management system. So it's software that is approaching its end of life. We've already talked to municipalities about the fact that we will no longer be supporting that, and that they need to find an alternate case management system.
So is that a burden that's just going to land on the municipal courts on how they're going to either run it till it dies, or they're going to get something new?
Mr. Chairman, that is correct. And the vendor that provides that system has already been in conversations with the municipalities on what their options are. We gave them at least a year's notice so that they would have time to work that into their budgets going forward.
And so that includes the software escrow, network audits, that's all part of that system?
No, Mr. Chairman, those are different. So software escrow is on a product that we are going to eliminate, Judges Tools. So we have this Judges Tools software we're going to eliminate. By eliminating that, we will also eliminate the software escrow that goes with it. We're going to cut back on network audits because we have a variety of ways to track our security and to make sure our systems are secure. So there is a network audit that we have paid for in the past that we're going to eliminate. So the cuts in this division cover a variety of things. It's not all related to the municipal case management system.
Okay, please proceed. Representative Schwartz.
Thank you, Mr. Chairman. So, Ms. Smith, if I understand what you just said, each municipal jurisdiction will be on their own to replace this system. Is that going to create a problem if they opt to different systems that don't communicate well?
Mr. Chairman, Representative Schwartz, if I can, I'd like to bring in Elisa Butler. She's far more well-versed in answering that question. So if we can, I'd have her answer your question, please.
Good morning, Elisa.
Good morning, Mr. Chair. Mr. Chair, Representative Schwartz, the municipalities will still have an obligation to report some data to the court. There are a number of municipalities throughout the state who don't have the case management system that's provided by the Supreme Court. And in fact, the majority of them do not. So currently, we only support about 8 municipalities on that case management system that was provided by the Supreme Court. It has been 10 in the past, but 2 of them have gone on and used their own case management system. So there is some obligation in some situations for them to still provide information to the Supreme Court, and that's especially true if they're using e-citations.
Further questions for Elisa? Representative Summers.
Mr. Chairman, no, my question's for Claire.
Go ahead.
Mr. Chairman, thank you. Claire, my question is just, and I could have looked this up, but I didn't do it. Have you engaged every unit within the courts in budget cuts? So are we looking at the totality of the units here? So my question is every unit engaged in a cut? That's my question.
Mr. Chairman, Representative Summers, every general fund unit has taken cuts other than the Judicial Nominating Commission because that one is so small.
So, Alyssa, I am not interested in going through option A and an option B, but if there are other members that would like to at least have that addressed, go ahead, Senator Kinski.
Yeah, I should know the answer to this, but are the municipal courts obligated to continue to collect the automation fee, the assessment on the cases that go through their courts? Or is that an option for them?
Mr. Chair, Senator Kinski, so the statutes, the way they read right now, the municipality, in order to collect the judicial systems automation account fee, and it's the same with the civil legal services fee, they actually have to pass an ordinance to collect that fee. And then if they use that collection to implement or maintain an e-citation system, so a system that gives e-citations to the courts, then they can keep a portion of that fee. That's the way the statute currently reads. So Mr. Chair, Senator Kinski, in the answer to your question, there is no obligation unless they decide to do so.
So, Mr. Chairman, why would they even participate? Why would they even bother with e-citation or any kind of automation if, in order to collect a fee, I think they have to send the majority of it to the Supreme Court, which is no longer going to support their systems, if I understand it.
And Mr. Chair, Senator Kinski, I guess the carrot there would be that they do get to keep a portion of it, and not all. You're correct. I believe it's $10 now, but I'd have to double check that statute. But if they decide to adopt an ordinance and they participate in e-citations, then they do get to keep a portion of that fee. So that would be the carrot, I guess, for the municipalities.
So I guess the question is there a value to them to do e-citations and to have that versus just doing paper citations? And what's the value to us or to the state by requiring them to do e-citations?
Mr. Chair, I guess the value would be to the courts themselves. Number one, it is much easier for the courts to process those citations when they come in through an e-citation process. There's a less likelihood of errors in citations because it's being directly imported into our system rather than people keying in information and data. So there's that, that's an advantage. The other advantage is their citations are fed into what's called our citation repository. So we have data about those citations, those municipal citations as they come in, and we can pull information from that citation repository if there's a need for that in the future. So I believe there is a value to that, to the state, and especially to the courts. I think if you talk to the clerks of the circuit courts, they really like e-citations. It makes their job much easier and much more efficient.
Thank you, Mr. Chairman.
Thank you. All right. Any further questions? Seeing none, please proceed.
Mr. Chairman, you indicated that you're not real interested in options A and B. So I'll just say we threw those out there. They are not options that the court or the district court conference are recommending, but we did put them in there as options if you need additional cuts from the judicial branch. Okay, so with that, we'll move on to the next unit. This is page SC 29. It's our judicial retirement. There are cuts of approximately $257,000 in this unit. We have had 2 retired judges and a surviving spouse who have passed away since this budget was created. So we're able to revert those funds. Are there any questions on this one?
So that's simply a reversion, which would happen no matter what. Right.
Mr. Chairman, that's correct.
Okay, thank you.
And page SC 31 is the final Supreme Court budget or unit. This is our Board of Judicial Policy and Administration. We've made cuts in this unit to subscriptions for resource materials and contracts for judicial education, totaling $38,575. Court recommends approval of these cuts. So that concludes the cuts for the Supreme Court and Circuit Courts. The next section is our district courts. And again, just a reminder, I'm simply presenting them because I assist the district courts in compiling this. I'll talk about what we've presented in this budget book, and Judge Wilking, as the president of the district court conference, is online and available for questions if you have any. So you'll see on page DC4, if you want to look at the summary of all of the district courts. The district court's committed to an overall cut of $100,000 distributed among most of the 24 courts, which you can see on this summary page. There were a couple of courts that were able to absorb slightly larger cuts to help out the few who just had no room at all for reductions. Now, as a reminder, a district court budget includes salary and benefits for a judge, a law clerk, a judicial assistant, and a court reporter, all of which are critical positions to the functioning of the district court. A loss of any one of these positions would cripple the court's ability to meet their constitutional requirements. They each also have a very small budget for operational costs. The cuts vary by court, but include reductions in travel, supplies, and other general expenses of this nature. The bigger commitment made by the district judges, as Chief Justice Davis mentioned earlier, is to absorb the functions of the Chancery Court if the legislature wishes to go in that direction. So while they have no room for substantial reductions, they can offer a cost-effective resolution for Chancery Court. So the rest of this section in the budget book just shows the specific object codes that were cut within each district court, and I'm assuming your preference is not to go through each one of those individually. So with that, are there any questions for me or Judge Wilking?
Well, let's go to Representative Summers first, because he's always the funnest.
Mr. Chairman, thank you. I'm the most ignorant on this. So my question is, okay, all the salaries are set by statute. So as opposed to the last question where I asked, could we cut 5%? If we decided to cut any salaries in this, it would have to be through statute. That's my first question. And then what are the, if it is set by salary is set by statute, then what is that for ancillary staff other than the judge? And then just as a note, the cut in this whole section is less than 0.5%, less than 0.5%. So that, you know, that's, I get it, right? But it is not much of a cut. So my question is, statutorily, what are those salaries? And can we change? That's a decision we make, right?
Go ahead, Claire.
Mr. Chairman, Representative Summers, the judges' salaries are set by statute. The court reporters' salaries are set by court rule. There is no set amount for judicial assistants or law clerks, although I can tell you many of the district courts are struggling keeping their law clerks because the salaries are so low. I will provide the information for you that you've requested as far as what would happen with cuts, but I guess I'll ask Judge Wilking if there's anything you'd like to chime in with on that question.
Mr. Chairman, just real quickly back to Claire. So as we break down those positions, I want to know, what are those positions that we could cut salaries on? And how much are they in total, really? You wouldn't want to pick out one judgeship over one district over another. So kind of, what are the total of those salaries that could be cut?
Okay.
Thank
you. So I think it's important to, and I think Chief Justice alluded to it, the salaries of circuit court judges, district court judges, and Supreme Court judges are all set by statute. And I believe either by constitution or by statute, their salaries cannot be modified while they are during their terms, which means that really there's nothing we can do to them. We can only do it to their who comes after them. And so that leaves the staff salaries is the only thing that we can really nudge by doing, across the board reduction of 1% or 2%, and let the courts figure out where they're going to take that. So I think we all understand that, but I just wanted to, Representative Hicks, or Senator Hicks, I'm sorry, Vice Chair.
Mike.
Mike, he's the senator from Teton County.
Yeah.
Yeah, anyway. No, I just wanted, just for the edification of the committee, it's in the Constitution, it's only Supreme Court justices and district court justices that we can adjust the salary during the terms of their office. So circuit court judges.
It's statutory for circuit court judges.
Correct.
Representative Stith.
Mr. Chairman, thank you. And for Ms. Smith, referring back to page 32 on the Board of Judicial Policy and Administration, and this board got created in 2001 or so as part of the Set Me Free statute. So my question is, if this committee were to defund it in whole or in part, would anybody notice? I mean, it just seems like the Board of Judicial Policy and Administration is something nice to have in good times when you've got money to fund all this coordination, but is it really an essential? It's not a body that decides cases or adjudicates things. It's not a body that's providing services to the public. What would be the impact of defunding it?
Mr. Chairman, Representative Stith, there are a number of things in this budget that are very important to the branch. So we use this unit for a lot of costs that benefit the entire branch versus, one specific court. One of the biggest things that we pay for out of this unit is drug court magistrates. So if you were to completely eliminate this budget, you would be eliminating all funding for those magistrates that cover drug courts throughout the state. And that is a very beneficial program. I think you'd find a lot of people would really have difficulty if that was eliminated.
Claire, could we have the circuit courts perform that function?
Mr. Chairman, we could, but then we'd have to probably backtrack on some of the cuts that we made to the special magistrates that they're using, because this would add to their workload. I think that's something we'd probably have to have Judge Christensen and his conference really look at if they have the time to absorb that function. Okay. There are a few other things that we use this unit for. The 100 series in this unit is used to cover payouts for when somebody retires. For instance, we have a district court that has a long-term employee that is going to be retiring next month. The total payout for her is roughly $15,000. A district court does not have vacancy savings to cover payments like that. So if that district judge did not have this budget to fall back on to make that payout, he'd have to leave this position vacant for about 3 months to cover the cost, and that's just not doable. So that's another very important thing that this budget is used for. And then we also use it for some common resource materials and things like that that would have to be absorbed somewhere else. We wouldn't be able to completely eliminate them.
Mr. Chairman. Mr. Chairman, Representative Summers. Mr. Chairman, thank you. And Claire, if there's one thing I hate in budgets, it's hiding behind a name that isn't what it is, right? It's kind of goes back to the Chapter 17 discussion we have with Kevin Hibbert all the time. If you're not utilizing this money for what it is, then it's important that you be honest with as you have been right now after we've questioned you, but it's important that the court be honest with us and the public where you actually spend these dollars. So as you move forward, look at creating a different name or a different unit name and be transparent with how you use the money. And not so much that you use the money the way you do, it's perfectly reasonable. It's just that by looking at this, we have no idea until Representative Stith asked that question, what you use the money on. And so we encourage that with all agencies, that it's just a transparency issue. Thank you.
Mr. Chairman, Representative Summers, I like that suggestion. So we'll definitely look into that.
Mr. Chairman.
Go ahead.
So Claire, remind me on DC4, when you show the various judicial districts, am I reading that right? Historically, we show that 9C and 9A, that budget there in 9A kind of encompasses both of them. Is that not right on those cuts?
Mr. Chairman, Representative Larson, I believe what you're asking is the cut that we're doing to 9A is almost double what everybody else is. That is one cut, that is one court. That budget had, because of the changes that district judge is making since he came on board just within the last year and a half, there are historical costs that have been built into that budget that he will not be using. And so he was able to cut more out of his, thereby offsetting a court that couldn't.
Thank you.
Mm-hmm.
Further questions? Please proceed.
Mr. Chairman, that's all that I have for you. So unless you need to hear from Judge Wilking on anything specific you'd like to ask her, then we are done with our budget reductions.
Claire, going back to I think it was page 32, SC 32, you've got $234,000 for dues and licenses. What are those for?
Mr. Chairman, a lot of those are the dues to the state bar for all the attorneys within our branch, as well as subscriptions to a number of resource materials that they use, such as Westlaw, LexisNexis, things like that.
So the dues for the attorneys are for staff at the Supreme Court, or for the law clerks, or for the judges? What's it for?
Mr. Chairman, it's for attorneys throughout the entire branch.
So logically, those should go into their individual budgets as opposed to here. So it's the same issue. So I think we're going to ask you to kind of rewrite this thing next time this comes around, so that we don't have to nitpick through this particular. And so our directive will be that we're going to eliminate the Board of Judicial Policy and Administration, but we want you to perhaps tell us how to do it and how you're going to accomplish it as we, I mean, unless you can give us good justification otherwise. So Chief Justice Davis, I see that you popped back up.
Well, I just, we got, Mr. Chairman, we got kind of buried in the question of what budget items are in the Board of Judicial Policy and Administration. This was, to my understanding, as Representative Stiff pointed out, one of the ways that was used to resolve a conflict between the district judges and the Supreme Court. The district judges have always believed, based on language in the Constitution, that the district court judges are not an inferior court under the Constitution, that they are not subject to the control, fiscal or administrative, of the Supreme Court. And then in, I think, 2001, that was enshrined in a statute, I think at the instance of one of the district judges. Right along with that whole process was, but somehow this whole branch has to work together. So the Board of Judicial Policy and Administration is the organ that does that. We have a meeting next week, and the board is composed of 3 circuit judges, 3 district judges, and 2 Supreme Court justices, and then I chair it. And policies that are going to be apply branch-wide go through that organization. And although the Supreme Court may have to adopt, for example, a rule change or something, things that affect the branch flow through there and come to the court with the blessing of this organization, which basically means all levels of the court are in favor of it, which tells us, okay, this is not some wild thing we're being asked to do. It's also a forum for discussion about various other issues, coordination of activities, and so forth. So the board has served a good purpose, and I think it's actually established by court order, but it is referred to in a number of places in the statutes, I know. So I would hate to see this committee say no more Board of Judicial Policy and Administration without some research into the functions that plays as an organ of the judicial branch.
I really appreciate that, Justice Davis. But what we see on this document has really nothing to do with what you just described. All of this is past our dollars and cents, and you can have that board and function as a board without having using this as an apparatus to fund certain things that it's spread out through the various judicial levels. And so that's what I'm getting at. I think the board's probably a wonderful thing. It's the idea that we're paying, we've got classified salaries, we've got doing different things with this from a budgetary standpoint that doesn't make sense for us.
Thank you, Mr. Chairman. I agree with you. It's the budgeting aspect of that is a totally different question than whether it's a good organization.
Yeah, so Claire, let's just work this out. We'll find a way.
All right.
All right. Okay, further quiz. Representative Larson.
Thank you, Mr. Chairman. And I don't know who this is to, but I just need a little understanding on the profession as a whole, coming back to the conversation on the dues. If I could get an understanding of how much an attorney's dues or fees are, and then the question comes back to me, is that typical if I were a practicing attorney that the law firm that I am employed by would pay those dues, or is that a personal responsibility? And so help me understand. So I'm trying to equate why the state's paying all of those dues. If that's standard practice, then okay. If not, then why?
So I think it's standard practice if you work for the state of Wyoming that the state pays those dues. The dues is $350 a year, and you cannot practice without paying those dues. So it's obligatory to have it if you're going to practice law. Amongst firms, I think it varies from firm to firm on who pays it and how that pays it. When I was in the Attorney General's office sometimes paid it, sometimes they didn't. Sometimes it was a budgetary issue. In the court systems, I think it's the same. I think it's vacillated over time, but typically they pay the dues. And for any firm of any size, they always pay the dues, I would say. Representative Schwartz.
Thank you, Mr. Chairman. So I'm not the lawyer. What happens with all that money that is collected in the dues? I'm not clear.
It's paid to the Bar Association to administer and operate all of the functions that the bar performs in terms of and Chief Justice or someone may be able to walk through those better than I, but so we have an ethics probe, we have we have the rules of practice, all those things that we do to self-monitor our industry, just like you see in other boards and practices in front that you see that are state entities.
Mr. Chairman?
Go ahead,
Senator
Mr. President.
Right. I mean, this is no different than engineers pay their dues to their state, the state board that operates and controls them. Doctors do, CPAs do, engineers do. They all have their professional boards. And we look, and so those boards then control and look at, and they're the ones that go back and enforce the statutory obligations imposed upon the various professions. And so the Wyoming State Bar is a little bit different, but that's the function that it has. So for example, when you read about disbarments, the State Bar Association are the folks that can, if there's a complaint or there's other information that comes that an attorney is not practicing in accordance with their canons of ethics or other obligations that they have, those are investigated. Sometimes there are discipline, sometimes there's no discipline, or discipline range from a censorship to a private reprimand all the way to disbarment. And so they do that. They also, like other organizations, they try to make sure that you have decent continuing education. They also promote pro bono and other civic work, free legal work. And they also have been great advocates with respect to the administration of justice among those who cannot help to afford it. So even though we have that program, they've helped a lot with making sure that those who can't afford legal services can get those. It's not their primary function, but they sure encourage it and do a number of things that help operate or help the attorney profession both look after itself and to protect the public. Thank you, Mr. Chairman.
Okay, any other questions? So I want to know why we haven't heard from the chief, Lily Sharp hasn't said a darn word, and we might not be able to hear from her again. Where's she been all day?
I'm hiding in the background.
This is an anomaly.
Okay, Claire, what else do we have? Anything?
Mr. Chairman, that's it. Right on time with the agenda.
Okay, any further questions? So with seeing none, I think it is 10 o'clock. So the next thing is Judicial Conduct and Ethics Commission, and that's set for 10:30. So we will take a recess till 10:15. Thank you. Appreciate it.
I wonder why back in the day, Bob, they saw fit to give the House windows but keep the Senate in the dark.
I thought it was always the other way around.
Well, when during the remodel, they exposed those windows behind you in the House chambers.
Oh, yes. In fact, that was a request by yours truly during that process.
Yeah, and no such similar windows on the Senate side.
I
You know,
believe,
we did have that discussion, and the way that you would really would have been nice to remove that the whole you know, the back above your dais, you have that seating arrangements back there that we don't have. That was stuck in there, and we looked at the cost of doing that, and it was just prohibitive, but it would have been pretty darn neat.
Oh, that seating arrangement was added later that we could have had windows behind the dais?
Yep.
Oh, interesting. Yeah. Well, what the hell? 10 million here, 10 million there, what, you know?
Mr. Chairman, I think the House is the body of light after all.
There could be some truth there.
That's because they've been in the dark so long and we need to shine some light on them. Or maybe they need to see the light of day, or I don't know.
Or we're blinded by the light now. All right, looks like we've got a quorum. Next up is the Judicial Conduct and Ethics Commission, which I actually just delayed for 15 minutes, but we're still on time. So looks like we have Mr. Gilbert here. Welcome, good to see you.
Thank you.
Please proceed.
Thank you, Chairman Nicholas and Chairman Bebout, if you're out there, and members of the committee. My name is Jay Gilberts. I am currently the chair of the Commission on Judicial Ethics and Conduct. And with me today is Wendy Soto, our executive director. As many of you know, this is a 12-member volunteer commission consisting of 3 judges, 3 Wyoming attorneys, and 6 laypersons also on the commission. The commission has performed its work for many years without making any exception requests. In fact, like the other agencies, it's sustained budget reductions. The commission is responsible and a conservative steward of the taxpayers' money, and I'm going to talk about that in a little more detail in a minute. The commission operates efficiently with its small budget, but even so, budget reductions are regressive for smaller agencies, and we all know that costs continue to increase. The reality is the commission is already currently on a very tight budget. The commission is a vital part of the integrity of Wyoming's judicial system, and it provides the avenue for citizens or lawyers to seek relief if they believe a judge has acted in an unethical way. Wyoming's judicial officers include 58 full-time state judges and 100 plus part-time magistrates and municipal judges. Adequate funding is necessary to protect the rights of the citizens and to allow the commission to fully investigate allegations of unethical behavior on the part of the judicial officers, bring charges against those officers if that is an appropriate step, and to prevent delay of disciplinary proceedings in order to fulfill the commission's constitutionally mandated mission. As we've explained in the past, the workload of the commission is unpredictable. It's dependent on the number and nature of the complaints that we get. It's impossible to anticipate how many cases will be filed, how many will need to be investigated, and if cases will be some significant amount of work, which will require more expenses, including attorney's fees expenses. Nor can we anticipate the gravity of the cases that will be filed during any biennium. For example, in 2012, the commission had 3 complex cases requiring that we hire disciplinary counsel on 3 separate occasions. In 2017, we had 5 attorneys perform work for the commission in that year. In the past year, we've hired 2 separate firms as disciplinary counsel. And in other years, although rare, we have not needed to hire counsel at all. The commission always negotiates with the attorneys for a reduced hourly fee from what their normal fees are. And the Wyoming lawyers are willing to do this for us at a reduced rate because they recognize the value of the volunteer work and the many hours the volunteer commissioners donate to the process. In addition, we require some funds for our contract services for temporary support staff and to provide coverage in the office when the sole employee of the agency is out on business or on leave. And what I want to tell you is that Wyoming citizens are fortunate to have a judiciary of the highest quality. Through my experience as a member of this commission over the last 6 years, I've had access to the disciplinary issues in all the other states. I've learned about the types of ethics cases in those jurisdictions, and I'm proud to report that we do not have many of these more egregious types of cases than these other states tend to experience. I believe this is largely due to our system of appointing judges and the quality of judges who are appointed and serve in Wyoming. But it's also because of the work of the commission and its ability to perform its function with adequate funding. To end here, I want to say I will be leaving my post with the commission after I think what's been 6 years of service on a volunteer basis in the next couple of months. So what its budget is as it moves forward is one I will not have to deal with. But I wanted to leave you with this. It is my observation that this commission is run on a very, very tight budget. Absolutely as much work of the commission as can be done is conducted with telephone conferences and Zoom or Google Hangout meetings, removing as much travel and other expenses as possible. And we were doing this well before the pandemic. We had spent years using this compressed video technology as a cost-saving measure. Executive Director Soto is an extremely frugal person. And when we do meet, as we need to occasionally, we use folded paper nameplates that she's printed out off of the computer. She requests that we remove the documents she's compiled for us for our meetings from the 3-ring binder that she supplied us so that she can take possession of those 3-ring binders and use them again. And she even asks us to put our folded paper name tags back inside the folder so it can be reused. I have needed to sign off on a number of things, and it's clear to me that Ms. Soto also reuses the sticky tab notes that she sends me in those mailings. And this is the way in which this entity operates in a frugal fashion. I wish we could accomplish the same level of recycling inside of my law practice. This happens in all aspects of what we do, and that this results in us operating on the very lowest amount of budget that we can while still getting the important work of the commission done. I personally urge you to approve an adequate budget that does not hamstring this commission, forcing it to choose between pursuing valid complaints against judges simply because we do not have the budget to do so. Thank you. And I'll now turn over a brief presentation to Ms. Soto.
Thanks, Jay. We appreciate it. Cindy, please proceed.
Thank you, Chairman Nicholas. Good morning to you and to Co-Chairman Bebow if he's available or on, and to the members of the committee. My presentation, as usual, is pretty short and simple. As you know, the commission's budget's very small in the grand scheme of things. Following the step 2 COVID-19 reductions, the commission will have a biennial budget of $333,535. The commission's budget covers the typical expenses of operating small office. It includes expenses for personnel, travel, for meetings and training, technology, office expenses, and the cost of hiring disciplinary counsel when needed. You can see the detail of the commission's proposed budget reductions on page 5 of our budget book, and then the impact of that budget that reduction on page 8 of our budget book. The only area of the budget where the commission can reduce its budget is the 900 series. The commission has 1 employee and there's no flexibility in the 100 series. And I would note our 200 series funds are only $31,990, which is $5,000 less than the 10% reduction that is requested through the step 2 COVID-19 reductions. So that is really the main presentation of our budget. It's like our budget book. It's pretty short and simple and to the point. So I'm available for questions if anyone has questions.
Thank you. Questions for Wendy?
Mr. Chairman.
Representative Schwartz.
Mr. Chairman, it's Representative Summers, but
Well,
Andy and I are relatively the same height, and now that he's got a gray beard going, you know, and glasses, unfortunately he does have some head hairs, or for me it's unfortunate, but
And I did
for him
raise
it's fortunate.
he had his hand up.
Yeah. Mr. Chairman, thank you. I'll just butt in. Thank you. Ms. Soto, I appreciate your you guys' work and your board's work, and I think it's important. And I ask this of the judges, and I know it's difficult, and I know it's your job. But what if we gave a 5% haircut to your job? And the reason I ask this is, what are other positions like yours in the state that are executive directors? Do you feel probably that your salary is consistent with those kind of other sorts of boards, executive directors? And, I'm not saying we're even going to contemplate this, but I think it's important to ask that question. So if you could talk about, frankly, your salary, you're it. So I've got to ask that question.
Chairman Nicholas, Representative Summers, if you're asking me about how my salary compares to other directors who do this kind of work or within the state agency, I don't have that within other state agencies. I don't have that information. I would have to do some research and could probably get some information to you about that. And I'm sorry, was there a second part to that question?
I think Jay wants to respond to that as well. Go ahead.
Thank you. One thing I'd ask you to bear in mind is something that I said at the beginning, which is that Ms. Soto is our only employee asked to perform all tasks: executive director, secretary, office manager, and all of those things. She does all of that on her salary. And so I would consider it inappropriate to reduce her current salary. Thank you.
Senator Hicks.
Yeah, Mr. Chairman, I was wondering if we could have some refinement in the budget on the personnel cost. Wendy, does that include also the reimbursements for the board? How much is salary? How much is benefits? Could we get that information from you? Could you break that out, a more detailed budget on the personnel side? Because it's the biggest expenditure within the budget. So, but where does the board, because they get reimbursed for their actual expenses and travel, where does that come out of the budget?
Mr. Chairman, Senator Hicks, the 100 series covers only my salary and benefits.
Okay.
The commissioners are volunteers. They get no compensation for their time. They are reimbursed for travel and lodging, which comes out of our 200 series, out of our travel budget.
Senator Schwartz.
Thank you. Finally, I have two questions. The first actually relates to travel, because I'm assuming, like all of our other agencies in the time of COVID, we're doing virtual meetings. It's I don't know, $22,000. You didn't reduce it. Do you anticipate reversions there? And then I'll ask another question separate. In your narrative, you state the number of cases has been fairly level over the last years, but you don't say how many cases? Thank you.
Go ahead.
Mr. Chairman, Representative Schwartz, we have been doing our meetings by Zoom, which we have done either telephone conferences or video conferences since I've been here for the vast majority of our meetings. The commission does try to meet in person to have a business meeting twice a year. And historically, we have traveled around the state for that meeting. But of course, this year, all of our meetings have been virtual. We have traveled some for educational programs. There are no local in-state ethics education programs for commissioners. So there is a national, the Center for State Courts has a Center for Judicial Ethics that has a national college every 2 years. So occasionally, every 2 years, at least one or two folks attend that. And I'm certainly, we're in a position where that may not be happening in the future. But that's the only travel that that budget covers. The one thing I would say, I must also add here, is that our rules require that if there is an adjudicatory hearing where a judge where there's needs to be an administrative hearing to determine if there's been a violation of the Code of Judicial Conduct, our rules require that those meetings be in person. So that is one rule requirement that we would have to meet in the event that that happened. Also, I'm sorry, I had intended to provide you all with a copy of our 2019 annual report. And I did not get it over to you, but I can certainly provide that so you would have an idea of the numbers of our cases.
That'd be great, Wendy. Yeah, you just provide that to LSO and we'll circulate it.
I'll be happy to do that.
Thank you. Okay, further questions? Senator Hicks. 1 second, Senator Hicks. Go ahead, Jay.
Thank you, Chairman. I just wanted to make sure that it didn't slip by in Wendy's statement about our travel, but should we have a case in which we are pursuing a claim of a violation of the code and the judge were to contest that case and we needed a contested case hearing, both our rules and I believe actually due process requires that we have that. It's a trial-like hearing and it must be held in person. And so part of our travel budget must contemplate the idea that we may need to have one or two of these hearings and travel for them. Those simply cannot be done, as I say, because of the rule and also I believe because of due process via some compressed video process. And I just wanted to make sure that was clear. Thank you.
And so, Wendy, I'm curious, typically, do you have reversions on an annual basis?
Chairman Nicholas, yes, we do typically have reversions, and that varies, of course, depending on how many cases we've had, how complicated those cases have been, and sometimes how long they've lasted. We've had cases that have gone over.
So whatever you don't spend comes back.
Yes, absolutely.
Further questions? Okay, now Senator Hicks.
Yeah, Mr. Chairman, Mr. Gilbert's just curious, and Wendy, maybe you want to weigh in here. So it's really a two-part question. Number one is you got a 12-member board. It seems like it might be a little unwieldy to have that many members on the board. And then being 12, that's always an interest. But what I'm curious of is, Wendy, maybe, so what's the average attendance of those 12 members at the board meetings? So do we have 12 at all of the board meetings? But so that would be one question. The other question is it seems like a lot of people on a board, given the limited nature of what we're dealing with here. So Jay, you may want to field that question.
Well, Mr. Chairman, Senator Hicks, if I would respond first, and I'm certain that Mr. Gilberts will also have a comment. First of all, the 12-member board is set by the Constitution. It's required by our Constitution to have that mix of folks. So that isn't something, and frankly, sir, it is not really that unwieldy. I'm always impressed with the quality of individuals who are appointed and serve on the commission, and I can tell you that our attendance is almost always 100%. Occasionally, the weather will require that we have commissioners attend by phone, but rarely do we have a commissioner who, for whatever reason, is unable to attend our meetings.
Okay.
Thank you, Chairman. So a two-stage response to that. The first is to say to you, I wondered a bit about that myself when I came on, and then I saw what I considered the brilliance of that composition of the board. And particularly when I compared it to the composition of boards in other states. And what you will see about that board composition is that you'll get a diversity of thought from the lawyer side of the equation, a diversity of thought from the judges side of the equation, but the lawyers and the judges together cannot outweigh the common sense of the citizenry of the state. And that's the brilliance of the composition, is that a consensus needs to be built between them. The other, and so that's stage one. It really is a beautiful arrangement, which has us all working together. And I think we can appreciate that a lot of minds puzzling over a problem is a bit more helpful than just one deciding what the right answer is. The second thing to bear in mind about the number is how things have to happen inside of the commission. So when a complaint comes to the commission, there needs to be an investigatory panel developed. And so a certain number of those members are carved off, typically one lawyer, one judge, and one or two lay folks, to look at the complaint and determine whether the complaint tells us there's a colorable claim of judicial misconduct. If there is one, then that subcommittee, this I panel, investigatory panel, then needs to take that matter up and investigate it and develop the evidence. And if there is evidence of it, be the body that hires independent counsel and proceeds with bringing formal charges of misconduct. Now, due to our constitutional requirements of a fair and impartial body deciding whether or not there actually was misconduct, the I panel cannot set on the adjudicatory panel because the I panel has already made its mind up. And so we need these other members to be part of the adjudicatory panel that hears and determines the evidence which is admissible to determine whether or not there has been a violation. And so we can see that once we are in a phase of addressing judicial misconduct, part of the commission gets taken out to be the investigatory panel. We need the remainder of the commission to set in order to adjudicate the actual case and set as essentially a trial judge. So that is in part why the commission is of the size it is. Hope that's helpful.
Thank you, Jay. Further questions? All right, anything else from committee? Seeing none, I think that concludes your testimony. Thank you again, Jay. Good to see you again. Wendy, nice to see you. Take care.
Thank you, Chairman Nicholas. Thank you, committee members.
You bet.
Thank you.
Okay, now we are on to the Attorney General's office. And Bridget, are you around, Bridget?
Mr. Chairman, can you hear me?
can.
Can you see me? We tested this yesterday and it seemed to work, but we had an internet problem this morning. And so everything got all topsy-turvy on us. So I just want to make sure you can both see me and hear me.
We can see you, but you're very far in the distance. I wish that you could.
Mr. Chairman, I will scoot closer.
That would be nice. I love your earring.
Sorry, I forgot to take it off. I was going to speak without it so you all could hear me. Sorry, we did experience some technical difficulties this morning, so we're sorry we weren't where we needed to be.
That has never happened to us. Please proceed.
All right, obviously I'm the Attorney General for the state of Wyoming. My name is Bridget Hill. I do have a few people here with me in the room. I will introduce them and then let you know we also have some of our unit directors on standby, so their camera isn't on, but if we have questions for them, they will be here as well. They're available to answer those and they'll hopefully turn on their camera when needed. Again, assuming we don't have technical difficulties. In the room with me, I have my Chief Deputy, Ryan Schellhaus. I also have our Interim Director of the Division of Criminal Investigations, Forrest Williams. Since most of the cuts came from the law office and DCI, we thought to have everybody on hand, not on standby. And then right behind me, who you probably see in the picture, is my Chief Fiscal Officer, Steve Winders. And he's here to keep me on track and to answer any questions that I can't.
Great, please proceed.
Okay, so we will get right to it. We were given to understand from email from your staff that the agenda one is tight, and so we should keep moving, but also that you wanted to go in page order. So what I intended to do then was to go through our cuts. I'll just give you a little general information first. Our general fund budget, and I know that's what we were originally trying to cut, is $61,808,078. So when you look at step 2 cuts, and generally the idea was to cut 10% in step 2, that amount of 10% obviously is $6,180,814. The reduction that the governor recommended to take for our agency obviously does not equal that. If you look through the budget book, or I know you've all studied it, our cuts into step 2 are $920,015. So we are not at the 10%. If you were to calculate that out, the general fund cut that we are taking is 7.5% of our general fund. So it's not quite 10, it's 7.5. We do not have any step 3 reductions, and nor do we have supplemental requests that we will talk about today. So it'll just be step 2 requests that I will be going through with you today. And to go in page order then, you know, I've done this for years and I don't know,
Mr. Chairman,
go ahead.
Representative Summers. Mr. Chairman, thank you. And Bridget, thank you. I just wanted to kind of pose a high level question to you before we get into each individual. And then, you know, as I look, and it'll be around your vacancy list. And so as you can get back to me on this or talk about it now. You have several positions currently on our November vacancy list. There's a couple that are filled. Several that are 100% general funded. So I guess my question to you is, if we sweep those general funded vacancies, what will be the impact? So you may want to think about that and provide that answer. But as I look at your agency and I look at all vacancies, it's not just you. I've done this with everybody. It's you know, what are these vacancies, and you know, if we decide to sweep them, what are the impact to your agency? you're a larger agency, so realize that I think that if we take this and you have a vacancy later in another arena, you can probably get that swapped. But I still want to understand what that impact. Thank you.
Sure. Mr. Chairman?
Go ahead.
Okay. Representative Summers, yeah, I have looked at our vacancy list as well. And obviously every cut to every position, to any position, impacts us in terms of our ability to meet our statutory mandates and our ability to provide services to the public. And I'm sure you've heard that from a lot of folks. That's what everybody's going to say, that it'll possibly slow down the work and it will make it much harder for us to do our jobs. And that's certainly the case with us. But in particular, with our vacancies list that I look at, primarily the ones that you see on that list are, a lot of them are at our Wyoming Law Enforcement Academy. And as we go through my budget, you'll see that we recommended very little cuts to the Wyoming Law Enforcement Academy, in as much as that unit of our office is struggling heavily already under the budget conditions they have and the ability they have to recruit people to Douglas to train up law enforcement. And so when we get through my budget and I get to the Law Enforcement Academy, you will see I recommended very little cuts there. And it was a cut that still is going to be painful for the Law Enforcement Academy, but it was simply a fiscal position. And we thought we could do some of that work from Cheyenne. It is going to cause additional strain on the fiscal staff here and may result in increased travel as well as increased duties for our director up there. But when you start talking about attorneys that appear on this list and DCI individuals, you again are talking about slowing down the work and making it harder for us to meet our clients' needs in the law office. And then in DCI, investigate criminal or crimes, I guess. I shouldn't call it criminal, something else. It's just crimes, to investigate crimes and to respond to members of the public. And so it would be tremendously impactful when you consider the cuts that we already have to our personnel. As you're well aware, 88% of our budget for the AG's office is in 100 series, which is personnel. And so, it's tremendously impactful. We don't have much else to offer. And it puts us, I believe, at a competitive disadvantage for hiring folks.
Mr. Chairman.
Go ahead, please.
Thank you, Mr. Chairman. Bridget, good morning. So I want to get a little clarification in a comment that you made where you said what the governor has recommended here is less than 10% and then no step 3. Is that different than what you recommended?
Mr. Chairman, Representative Larson, we obviously, like every agency, were asked to identify more cuts in the event they would be needed. I did not recommend those. If you're asking me, I say I could live without them, but they were identified. And then the impacts of those, I believe, were catastrophic to our agency. So they were identified, but I would not say recommended.
Bridget, can you provide for us kind of a breakdown of the number of attorney generals over time? And I ask that because this is the first time since I've been in the legislature where I've seen any type of substantial reduction in attorneys. It just hasn't happened. In fact, we tend to add them versus subtract them. And the first time I've really seen a combining duties and responsibilities. And I think it might be helpful to the committee to see that over time. Go back 20 or 30 years and the number of attorneys and how because it's been a pretty dang steady growth. I just think that would be a useful information for us.
Mr. Chairman, I would be happy to do that. Obviously, I don't have those numbers off the top of my head. My sense of it, though, would be the same as yours, that over time we have added more attorneys as we find more legal work for the state, as the society gets more litigious. and whatnot. But I'm happy to go back and find those statistics and provide it to you later. But I would also agree with your sense that this is the first time you really see us cutting what to us is a substantial number of employees in the law office.
Mr. Chairman,
Go ahead.
Representative Summers and Bridget, thank you. I have one more question on one specific vacancy. And that is the human resource manager one, which is the 124th on our vacancy sheet, 0150181. And I'm wondering, it's been included in a centralization. Does that mean there's no general fund money left in that position? Because we've had that question yesterday on some positions in A&I. And so I need to understand whether there's any general fund money left in that position.
I think Kevin just popped up to answer that.
Yes, Mr. Chairman, I think what Representative Summers has pointed out is very important to the conversation we had yesterday. That has been identified as a position that is going to be rolled into consolidation, and when consolidation is complete, as Director Bach suggested yesterday, several positions, in the 20s, et cetera, will be reduced in state governors through that consolidation. So the consolidation is important to understand. So in that case, we want to leave that position alone, work in consolidation, and then the outcome of consolidation will lead to reductions across the enterprise.
Mr. Chairman, just a quick question for Kevin while you're there. Well, obviously, if we cut that, we did the consolidating right there. So
yes, and you put us in harm's way.
Yeah. Well, I guess my question is, though, on this particular position, is the money, the consolidation has not happened. The money is available if we so choose. Is that accurate?
I think we need to consolidate, bring the money in, and then make the reductions in the consolidation through the consolidation effort. Otherwise, it's going to get very difficult for us to manage that consolidation. I would point out that the approach that we're taking with HR consolidation is a much cleaner, planned approach than what we experienced with ETS. We're diligently making sure that we work all these avenues. So it's going to take a little bit of time, but the consolidation will ultimately result in a significant number of positions reduced in state government.
And so, Mr. Chairman, a follow-up on that, but that consolidation is not reflected in this budget. So that consolidation is something that would happen in the next budget.
Or through the B11 process between now and when we get it accomplished in the spring. We're diligently working on it, but it's complicated. But we're asking that you allow the process to go through the process. And then ultimately there'll be many positions in the total enterprise reduced through the consolidation. But if we start stabbing at it now in the blind, it's going to overcomplicate it and we're going to find ourselves back into the ETS world. Now, what we want to accomplish is transparency, clarity, and get it right, get it done the first time, all the way through the statewide cost allocation and the federal bills and everything else associated with it. It's complicated, but we have a good plan in place. So please give us the opportunity to complete it.
So, and actually to answer that question, Representative Summers, is that if we don't eliminate the position anyway, we just take the funding away from it, if that's what we choose to do. And so we really don't impact that other than the impacts to the overall budget. And that would be a Bridget problem when that happens.
It would actually be a consolidation issue with Trish when we ultimately have it over there inside of A&I. If you take all the money on those consolidated positions, and you have just created a situation where we cannot complete the HR responsibilities for the state of Wyoming.
Mr. Chairman, just a quick follow-up. So, Mr. Chairman, thank you. Kevin, in the past, JAC has been tried to do the 100 series light version, where we cut positions, give the governor flex, do all of these things to reduce positions. And in the end, the last go around, we basically were told, well, we're not going to do it. And so, I don't know what my confidence level is that, if we went that route as a JAC now, we could go, hey, 100 series, we could even ask you, Kevin, what's your consolidation going to result in a percentage of 100? we could build in that to the budget, and then you would have the obligation to do it in the end, or ignore us. So I guess that's my question back to you, is we can do this, I guess, position by position, or we could work together to try to figure something out that would be reflected in this budget moving forward.
So my response to that would be is I've been working on this diligently, trying to accelerate it, just exactly what you're doing, Representative Summer, push the gas. But the brakes are all the complicating factors that we have with funding sources and everything else associated with consolidation, and actually having it mapped out properly. So the ultimate objective, and we're all in the same position on this, is that we want to have
Nikki, get out of there. Hey, get out of that garbage can.
So what we're wanting to do is we want to all collaborate to where we have a significant reduction in the HR costs in state government. And that includes position reductions. I'm pumping the brakes today because what you suggested is, why can't we do that today? If I had a clear path to where I had all the information that was necessary, I would suggest that already, and I don't. But also, I do not want to have a repeat of what we had with ETS. In the end of the day, you should be able to see clearly what we did with the consolidation, how that consolidation was brought over to A&I, and the reductions that A&I took in place on the enterprise to have a significant number of fewer bodies in state government. But there's challenges to this. Those challenges would be how we ferret out the federal dollars where they are located on positions and several other things that do not give me the ability to have confidence into just punching this out directly.
Well, and Mr. Representative Summers, if we want to do reductions to the AG's office, we can find other targets other than the one position on the HR list. So we can skin that cat in numerous other ways. And that reminds me, I want to know what the heck Senator Perkins put in the garbage can that had Nikki wanting to get in it in the first place. But go ahead, Bridget.
Mr. Chairman, if I could just explain as it pertains to my budget, what I understood, why this shows up on my vacancy list. It was my understanding what I've been calling the back end accounting has not happened yet. So it appears on my vacancy list yet. But if you're asking me, Representative Summers, if I intend to fill that position, no. It's my understanding that position is no longer mine to fill because it will be part of HR consolidation. So since all the technical back end accounting hasn't been completed yet, it showed on my vacancy list, but I have no intention to fill it. I believe it's not mine to fill anymore. I just wanted to make that clear.
Thank you, Bridget.
Okay, please, Senator Hicks, Mr. Vice Chair.
Mr. Chairman, while we're on the vacancy list, Bridget, we've got the one for the 2 AWACS with the potential school litigation. They've been on there for decades, over a decade. But I see on that the funding for those says other funding. I'm assuming that that's coming out of the school foundation program. And I'm also assuming that those funds revert back to the school foundation program every biennium. So that's two questions. But do we really need to keep carrying these positions for over a decade?
Mr. Chairman.
Go ahead.
Senator Hicks, I hear what you're saying. I asked the same question a little bit when I first got here because I didn't understand necessarily why they are there. I would urge you to keep them there, and we then will have them available and won't have to go through what I call technical hoops should litigation occur. And you're right in the middle of recalibration. I feel like we've got school districts, what I would call spoiling for litigation. So we want to have them readily available should that happen. And so I do believe now is a critical time to keep those on the books, if you will, so we have them available should we need to use them. As to your second question, that money does revert, but it reverts to LSO. It does come out of the school foundation. Yeah, I think you saw me nod when I said that, but it reverts to LSO if it's unused by us.
And then Don, do we revert it back?
Mr. Chairman, members of the committee, no, we do not. So we saved that up over a period of years, and that's what's used to pay for the recalibration and the consultants.
So Mr. Co-Chair, just to follow up on that then. So Bridget, when I look at those salaries, what kind of work are we going to get on school litigation for somebody that's going to be paid $24,000 and $37,000 a year? So what would these people be doing at that low level of salary?
Mr. Chairman, Senator Hicks, we believe those folks would be folks that would be helping us with discovery. So they would be more the paralegal type. So they would be helping us with discovery and investigations and those sort of things. We did not really anticipate those to be attorneys.
And just to follow up on that, Mr. Co-Chair, so I'm assuming those are the salary levels as to when those positions were created or you know, 120 some months ago. So is there even a sufficient money in there to hire a paralegal?
Mr. Chairman, Senator Hicks, I do believe so. Your point is well taken. I do think we've captured a little bit older number there, but certainly we could use the money to hire a couple of them. But your point is well taken. It's old dollars if you're saying it's an old market, but yes, we still believe we could hire some to help us out.
All right, thank you, Mr. Chairman. Thank you, Bridget.
Mm-hmm.
So I guess this goes back to Representative Summers' discussion that we've had. It's just an odd way to fund recal and to have something on the books that because it's just not transparent. And it's why don't we do what we actually do and make it so it's easy to understand at the end of the day. It's just peculiar to me. So all right. Representative Schwartz.
Thank you, Mr. Chairman. And this came partly off the school foundation. At some point, could you get to us? Your other funds is almost $14 million. And I tried to go through all your budgets and track what the various other funds were. And I finally decided it would be quicker if you just sent me a list of them so I can figure them out.
Mr. Chairman, Representative Schwartz, yes, I'd be happy to pull that chart together for you. It would not be complicated for us.
Okay, any other questions? Seeing none, please proceed.
Okay, let me take you to the chart then. I always like to start with the chart. So the first chart we'll use is the one for the law office, which appears on page 21. And then I'll explain the reductions you see on every chart for each of our units. So our first unit is unit 101. That is our law office unit. And what you see first there in terms of our reductions are you see a reduction of 1,086,768. That would encompass, if you look at our, and I don't know if this is how you like to do it, but if you looked at our priority list for our cuts, I'll tell you the numbers that would encompass in case you want to go look at the explanation. But that would include our priority 4, 9, 10, 11, 12, and 13. And generally what that is, the one we've cut attorney and paralegal positions. We've cut 4 attorneys, 1 paralegal. Then the remaining money is a little harder to explain. What we did was combine our tort deputy position with our school finance supervisor position into one whole position. So the person now at the head of our school finance unit is now going to serve as the tort deputy as well. And so what we did to accomplish that was take half salary for both of those, since we figured they'd be doing half duty. So half now of his salary will be paid by the general fund. Half of that salary will be paid by the school foundation out of the school finance.
So Bridget, at one point in time, that position for the school finance issue was the highest paid position in the AG's office. And I think we reduced it some, but is it still up around 150, 160,000 a year?
Mr. Chairman, it's right around 140. But what you will see when I get to the school finance one, then it's still included. You're right. It was sitting budgeted at 150 or 160, but we also reduce it to the current incumbents. So you'll see that cut when I get to the school finance.
Okay, thank you.
Mr. Chairman, Representative Summers. Mr. Chairman, thank you. Bridget, just in your law office, we had a discussion with the courts just a few minutes ago about the bar fees. So do we, the state of Wyoming, pay the bar fees for the attorneys, or do they pay their own bar fees? And if so, is that in that 360,000 in your 200 series?
Mr. Chairman, Representative Summers, we were paying the bar dues for our attorneys within the state. You will see in you are correct, it was in the 390, but we're proposing the cut of 43,000 in our 200 series. That is bar dues. So we will no longer be paying bar dues.
That'll make everybody happy.
Yeah, I'm super popular. Super popular. So if there's nothing else to explain in the 100 series, I think I've jumped ahead to the 200 series. So you do see a $43,000 reduction there. That was to eliminate the funding for bar dues. The impact of that, of course, is besides making me super popular, it actually does have an effect on our attorneys and the law office in general, in terms of making us less competitive. It makes us a less attractive employer. It's a cumulative effect of paying under market salaries. Most law offices pay their attorneys bar dues, so we'll no longer be doing that. And now you're seeing some increased costs in insurance, and you're seeing increased employee portion of retirement. So it contributes to the cumulative effect of making us a little bit less attractive employment option. Can I just circle back to the 100? I think I've already explained what the problem is there in terms of impact, but we were told to say the impact of all of our cuts, and I feel like I didn't do that justice on 100 series. And so I just want to make that comment that it does require us to rearrange our office and have people double up on some of their duties. And so what I have to do with my attorneys is essentially rearrange my office to our most, what I would call mandatory work. And that would be our work driven by court deadlines, our statutorily required work. So that would be things like our criminal appeals, our suits against the state, our termination of parental rights, because those are all driven by court deadlines. So I have to send some of my attorneys to that work, which means the work that will suffer will be the work where we give our day-to-day advice to our clients, the work of filing intervening natural resource briefs. That work will slow. I do believe it will mean we'll settle a few more cases because we simply won't have the attorneys to get them done. But I just didn't want to let my 100 series pass without alerting you to the impact of that.
Speaking of that, Bridget, I do have a question on the litigation with Washington, the Montana, and you probably heard the price tag, or you know the price tag of 2.5 million. And that number really doesn't make sense to me. I know that your predecessor, he took one of the water cases to the Supreme Court and argued it himself. What is your plan in that litigation in terms of having staff, one or two staff members, be part of and do a lot of the legal homework and literally kind of get educated and be part of that litigation so they understand and learn how to do it versus farming the whole thing out? So I'm just curious what your thought process is on that.
Sure, Mr. Chairman. First, I would note that we use that number as what I would call a worst case scenario. A lot of the fees that will be paid in that include fees to special masters if they take the case. That starts to run up your cost. But the difference in this case from the one that Pete did or General Michael did, was we are in that case together with Montana. And so to some extent, we have to be a good partner and, and work together to figure out how we're going to staff that case. So Montana's preference was to use outside work of a different firm. And so we agreed to that for certainly the first phases. We agreed with Montana though, so that's the filing, what we've already filed. Certainly we also indicated to Montana as the case goes along, it would be our preference to do exactly what you had indicated, some of that work ourselves. And so we are exploring those opportunities with Montana. So we came up with a number that was the worst case scenario in the event as we partner up with Wyoming, we have to, as we partner up with Montana, we have to make adjustments along the way.
What's the tentative schedule for when the money we need it? Are there deadlines or timelines that are typical?
Well, so it really depends on if they take it or not. We believed, so part of the reason we wanted to ask early was if they do take it, we believe we would need at least some funding immediately to start the work. And so this was the number you've been given is what I would call the whole boat. But we thought just to let you know ahead of time, it made sense to tell you the whole boat ahead of time, ask for that money. So you're not surprised later. So it's not us coming back every 6 months saying, oh, that's not quite enough. Now, do we need the whole boat at the start? I don't believe so. But the rationale for presenting that whole thing was so we wouldn't have to repeatedly come back. And that was what we truly believe to be a worst case scenario.
So then the question is, if we give you $1 million, does that last till the next budget session?
We would hope that it would, yes.
Okay.
Yes.
Go ahead.
Hard to tell, but we would hope that it would. Okay, so if there was nothing in the 200 series, I'll get you to our 900 series. You'll also see a 70,000 reduction in our 900 series. The reduction in the 900 series is us trying to tighten our belts the best that we can and hopefully not contract for work. You know, what our 900 series is really spent on is for the costs of litigation in some instances, so serving process, but also hiring outside counsel in instances where we have a conflict of interest. So for instance, the last thing we saw would have been that case with the Wyoming Public Defender's Office when they had the show cause and when they were found in contempt. Technically, we're required to represent both those parties, the circuit court and the public defender's office. So we had to find an attorney for outside of that. And so we're hoping to tighten our belt and do the best we can with 900 and the reduction is 70,000.
Okay, please proceed.
Oh, okay. Then I will move us to the next unit. The next unit that we have is our Medicaid fraud unit. That will be the table that I like to refer to will be on page 24. And in that unit, you will see a reduction in our 300 series. This is our number 6 priority on our reduction priority list. It is an amount of $91,360. And the concept here was this represents what we would say our cost allocation to the federal government. The concept was to take, as you know, this unit is funded 75% federal funds, 25% state funds. And the thought would be, could we reduce the state funding or the state match by 10%? And so our recommendation was to reduce our general fund portion of that, which is $22,840. But that leads to then a reduction in the federal funds. So that led to the grand total of the $91,360. So cost allocation obviously is something where you're billing the feds for their part of what I would call administration. So the budgeting, the services that they use for the state, the administrative services they use from the state. And so we would anticipate reducing this. I will say for this, there's been a little, what's the word you would use, Steve? Chaos? Yeah. Chaos is maybe not the right word, but I'm going to use it anyway. A little chaos in the the cost allocation method with the feds, and we've been working through that. And so over time, this has seemed to be an amount we haven't been able to use because of those troubles. It looks like the feds are going to a direct bill method, which we would hope would be implemented, and so we would be able to absorb this cut with relative ease.
Okay. Representative Schwartz.
Oh, excuse me. Thank you. So looking at this, there seems to be two categories of cases in Medicaid fraud, and one is the basic fraud and the other is abuse and neglect in Medicaid cases in institutions. And I'm curious what proportionally you're mostly dealing with, number of cases. If you don't have it right off the top of your head, but I would like to look at that.
Mr. Chairman, Representative Schwartz, we'd be happy to give that to you. Just off the top of my head, sense of it is we would personally prioritize abuse and neglect, right? Because that's a problem. But Medicaid fraud is something that comes to our attention more easily from the feds. But I'm happy to get that number to you, and from the way people report. So fraud comes to our attention more easily. But if we were to prioritize personally within our own unit, we would obviously prioritize what puts people in jeopardy. And so I'm happy though to get you those numbers.
Representative Summers.
Mr. Chairman, thank you. And that kind of gets to my question, but not entirely. You know, Bridget, what I want to understand here in practicality, and I've read your write-up, but in practicality, is this going to will this reduction have, will you quit doing investigations? In other words, have you not been able to do the investigations that come across your desk and prosecute the cases that have come across your desk already because of funding shortages? And will this further reduce your ability to do that? Or have you in fact been able to do everything and you think you'll still be able to do everything? Tell me the practicality of what this will do.
Mr. Chairman, Representative Summers, this one in particular, well, first let me start with this. We're a very small Medicaid fraud unit, one of the smallest, I think, in the nation. And so already our staffing is low. And so we do have to prioritize cases as they come to us already. But with this particular cut, what I had indicated when we were writing up our write-up, every cut takes a little whittle at your ability to do investigations. As I just stated though, for this one, we do believe we'll be able to absorb this with relative ease because of the weirdness that has gone on with the cost allocation.
Representative Larson.
So Bridget, could you help me understand the coordination with your Medicaid fraud unit in healthcare financing in the Department of Health? You guys prosecute it, and don't they have a fraud unit that investigates that? Help me understand how that coordination works.
Mr. Chairman, Representative Larson, there is a coordination there. And so in that way, I don't know how to explain it other than share information. We coordinate with each other in order to identify what we believe are troublesome payments or payments that would alert you to you believe there's an issue there. And so that coordination is together with that office in terms of working together to identify the fraud and then have our office take over the investigation and run with the ball from there, if that makes sense.
Well, it does, Mr. Chairman, follow up. And I think that it's fair to assume sometimes people think that that's just perhaps an elderly couple that didn't report their assets maybe as well as they should have. But the reality of that, and this is my question, is we see that sometimes in providers and in recent years, we've had some pretty significant fraud cases that you've had to deal with. Is that not correct?
Mr. Chairman, Representative Larson, that is correct. I do think people think exactly as you said, this is an elderly couple that didn't declare all their assets, but but it's many faceted. It is providers, it's providers of home care that you sometimes see where those payments are not accounted for correctly. And that's something we need to take care of. And so it's all kinds of care that would fall under Medicaid. And it is nationwide, it's a significant problem. And I believe it's a problem in Wyoming as well.
So I forgot to ask earlier on, Bridget, but what type of funding have you received for your implementation and work on reviewing all of the CARES Act applications, and how does that occupy your time? And I presume that all of your extra time is being compensated through as part of those funds, and how is that accounted for?
Mr. Chairman, so yes, it's occupying a lot of my time, a significant portion of my time these days. But what we're doing, I think we're looking at it on a whole statewide level of what we want to do with payroll in terms of what the state has done for CARES Act. And so the idea would be that we would be able to compensate payroll for people who were directly responding to and otherwise meet the requirements of the CARES Act. And so it's my belief we will be captured up in that, but we're looking at a whole picture. So I've had my people accounting for their time in terms of CARES Act. So when that gets sorted out, we will be part of that.
And roughly what has been allocated towards the AG's office for this?
Mr. Chairman, I wouldn't say we've allocated a dollar amount specifically to the AG's office yet at this point. I think an amount has been set aside for state payroll. And I don't
think that's 40 million. Was it 40 million is the last one I saw?
Mr. Chairman, you're going to think I'm the worst, but there's so many CARES numbers rolling around in my head. Yeah. I can't recall that
well,
one.
My question is, once it's allocated and recaptured, then and you get paid, where's the money going to go that was already paid?
Oh, sorry. I'm sorry. I misunderstood your question then, Mr. Chairman. Actually, what that will happen is that will just all go to the general fund. And
so you will revert back the general fund dollars as a substitute when the CARES Act comes in.
No, actually, I think we will just put it all in the general fund.
Okay. Yeah, I see.
Yeah. And so it would, right. So you're not really making one agency that thought, right, a budget bonus. The thought was to benefit the whole state and the whole general fund for what has taken place with CARES. And so it definitely has to meet the requirements of the CARES Act, and it will, but the thought was the ease in accounting was just to put it all in the general fund.
So with regards to the timing of that, theoretically, that all has to happen, and the cutoff date will be December 31st. Then you'll complete the accountings from each agency. And so theoretically, by February or March at the latest, we ought to have a sizable transfer of dollars to the general fund.
Mr. Chairman, and I would want somebody that's actually doing the accounting to speak to this, but my understanding of how it would work would be that, yes, we would, the CARES Act obviously cuts off at December 30th. But they allow you, as long as the services are provided before December 30th, essentially 90 days to do the back end accounting. Again, what I call the back end accounting. So you could make those payments anywhere within the 90 days. I don't know what's been decided with the auditor's office and all the transfers of funds as to when that would actually occur.
So Erica is going to tell us how much money we get. And
Good morning, Mr. Chairman. Mr. Chairman, members of the committee, Attorney General Hill is correct on that. So we're looking at roughly around 40 million right now for the payroll that we would get. We chose to only look at select agencies that we thought could have the 50% of the time allocated to that, and that we could get the most amount back within the littlest amount of time in looking at those agencies. She's correct in that it's going to go back to the general fund. We are working through those figures right now and have that allocated right around. It's going to be a little bit more than 40 million. And last conversation that we had is, as we're looking at shuffling those funds, I would assume that transfer is going to take place before the end of the year for that to go back to the general fund.
Thank you. So I just think we need to know that because that'll actually be part of our at least one-time budget capabilities on where we go. So, all right, thank you, Erica. I appreciate that. I had one other question, Bridget. Your consumer protection account has about a $10 million balance. And I'm curious why you don't use some of those funds as for your, are there restrictions on those funds? Where are they supposed to be spent? How can we take advantage of those funds if we can to offset ongoing expenses of your office?
Mr. Chairman, those funds are generally restricted. They have to be spent. They come from settlements, and they almost always have to be spent on consumer matters. So if we wanted to utilize those funds better, we would have to grow our consumer protection unit. I can't use those funds to fund other attorneys in my office because they come with restrictions.
So what do you do with the interest? You have to use the interest as well?
Let me just remind myself.
Excuse me, Bob, what page?
We have been
14.
Sorry, we have been placing that interest in the consumer protection account. I don't believe the settlements themselves would say the interest would have to go there, but it made sense to us to keep accounting for the interest in the consumer protection unit again, given the requirements that those funds be used for consumer protection.
Well, it seems perhaps logical that you could use that for your consumer protection division.
Right, and that is, oh, I'm sorry, Mr. Chairman, I thought.
No, go ahead, I'm sorry.
That is what we use that interest for. So our consumer protection unit is funded out of those funds too, but it is growing the fund. The insurance is growing the fund as well, or the interest is growing the fund.
Okay, thank you. Please proceed.
Sure.
Mr. Chairman, I got one further question. I want to get a little clarification, Bridget. I'm going back to your Medicaid, your cut, and what you told me was you do prioritize current cases. My question still is, are you getting all the cases that come before you investigated? Period. I mean, are you having to like throw stuff aside because you don't have enough work or enough money now? So I want a little better understanding of that, or you can send me that. I don't.
Sure, Mr. Chairman, let me say it this way. I don't think we throw any cases aside, but what we do is prioritize it lower, which means it takes us longer to get to. And then we would, on ones that are a lower priority, we would maybe try to reach some sort of amicable settlement before we have a full investigation, if that makes sense.
So Representative Summers, I can tell you that I've been involved in some of those cases, and I wondered why in the world is the AG's office pursuing this frivolous little claim. So I think that they go after everything they can.
Thank you, Mr. Chairman. I wouldn't say frivolous, but I would say we don't really let any go. That was my point.
Okay, please proceed.
All right, that leads us to the school finance litigation unit, which is our unit 115. That chart appears on page 26. And here you will see the reduction of the 442,844. Now this corresponds what I already talked to you about up in the law office. This is our priority number 4. But the reason those numbers are different then is we eliminated the full amount in this unit, and then we reduced the salary. So one position you see going away in this unit, but half of the salary went up into our law office. But that's what's going on here with regard to our 100 series. I would just note, because I thought it was odd on the bottom of the chart, it says we reduced it by a part-time employee. Apparently this was a little bit odd accounting from the past, historical odd accounting. That's this position that we're eliminating here has apparently always been accounted for as a part-time employee, even though they were a full-time employee. So we didn't mess that up. We just got it out of the part-time employee part. With that,
Mr. Chairman.
Oh.
Stiff, go ahead.
Mr. Chairman, Attorney General Hill, on the school funding equity litigation, if there is, if the legislature were to cut the school foundation program significantly and the school districts didn't like that, and you did have school funding litigation, would you have to come back and ask for more money in this unit?
Mr. Chairman, obviously Mr. Chairman, Representative said, yeah, it's hard to say. Obviously litigation is expensive. And when we go to that, I do believe we would have to make some exception requests. That's not really pending litigation right now. And that's what we did in the past. I'm just looking to my CFO to make sure that is what we did in the past. We would have to come to you and ask for an exception request if litigation actually got going. So part of the reason we have employees in here is to avoid litigation. So part of their duty is to obviously advise the legislature as you're making decisions about school funding. It's to correspond and outreach to our school district partners and try to avoid litigation altogether. But yes, if we had an all-out litigation, we would have to come ask you for money.
Representative Summers.
Mr. Chairman, if you could quickly tell me, do you utilize any of your 900 series? I mean, as I'm looking at all budgets that have S5 in it for agencies, one way to cut some school foundation, frankly, is to cut dollars out of agencies that have school foundation. So are you using your 900 series at all?
Mr. Chairman, Representative Summers, we do use our 900 series. That's the expert. We have an expert on hand that is available to you. And so we use that sort of contract. Help me with another one. We think it's 50,000. I can't pull it up right now on my 900, but we do use some of that money. What was the other one?
That's the primary one.
The primary one is the expert, but we don't use it all, I don't think, but it's to make.
Yeah, can I follow up on that, Bridget? Do you retain a regular expert, $50,000 a year or $25,000 a year, who just basically advises you and is available to us on the school litigation issues?
Mr. Chairman, that is correct. And he's been retained for a long time. Let me just say this, he's been historically retained. It helps with recalibration. It helps with, in terms of, we're not the people that really know the numbers, or we're not the experts on what the level of education you have to provide is. So he's not an attorney. He's an expert related to the funding mechanism itself and the level of the services you're providing to the school districts.
So Albert, through education and recal, are we familiar with who this is? And do we know if works through him, or do we have any?
Mr. Chairman, unless it is our current consultant that does our work on our model and they're paying part of that bill, I have never in my 3 recalibrations ever seen this expert. So if it is Picus and Auden and they're providing information to the Attorney General's office, then that's fine, but I have never in 3 recalibrations seen this guy ever.
So Bridget, I think what we'd like is just if you can have someone do a little 1-page memo to us on who it is, what they do, if it's a retainer, if they provide hourly work services, so we can see what they do. And I'm curious if you've ever done an analysis of whether or not it's reasonable to keep them on board, and if so, just give us a little white page on it.
Sure, I'd be happy to do that. I do know the gentleman's name. It's not Picus and Auden. It's Richard Cedar. Richard Cedar. And so he's been around for some time advising our office, but I'm happy to get that together for you as well.
And we'd like to know how much work he actually does.
For sure.
Because it'd just be interesting to find out for all of us.
Absolutely.
Okay.
We will get you that. We're adding it to our list.
Please proceed.
Mr. Chairman, that leads us to we're now into DCI. And so I'll take a swing at these, but just remember that Interim Director Forrest William is here to answer questions as well. And if he's needed, I will let him have this seat.
Sure, and when you're presenting, we'd like to learn a little bit more about the overtime salary, because that's something kind of new on our agenda.
Sure. And I will have Frosty come over and tell you a little bit about that, but I'll start with the chart. So that's on page 32. This is what we call DCI operations. And so you do see a reduction of 1,058,426 in our 100 series there. That includes our priorities 8, 21, and 27. And by priorities, I mean our reduction priorities. So the first one is the DCI overtime. We reduced that by $495,000. Now, DCI overtime has always been out there in terms of sometimes when criminal investigations come up, we have to send our investigators out for overtime. They might have to go on a weekend. Crime happens at different times. They might have already put in 40 hours a week, and so they might be working through the night if crime happens there. So let me just finish with the other two, and then I will let Mr. Williams speak to this. Then the other two were to eliminate the deputy director position. And we are covering that with our interim director picking up some of that work and then spreading out some of the work to our operations chiefs, who will pick up the work that will be, that was traditionally falling on our deputy director. The other one would be to eliminate a sworn law officer position, which I don't believe we've done before. So I will let Mr. Williams speak to this. You're going to get a dizzy real quick. We're going to switch to Mr. Williams, and I will let him address the overtime.
Welcome, Frosty.
Thank you, Chairman.
Go ahead.
So in regards to the overtime, as the Attorney General mentioned, we cut the overtime budget by $450,000. It's my understanding that's approximately half of the total amount of overtime that we did have available, and that's generally funded. One thing in regards to overtime I would like to point out is that we do have other federal grants that we utilize, and I think we've been doing a very good job in the last couple of years of trying to utilize that overtime money that's available through grants. Specifically, like our Internet Crimes Against Children grant leaves us with the ability to tap into that for overtime, as well as our HIDA grant.
Okay, appreciate it. So,
Mr. Chairman, I got a question on that.
Sure, please proceed.
Mr. Chairman, thank you. You know, and I've wondered this kind of with all agencies on this overtime, as we get into a budget crunch, what if we cut all of your overtime? So obviously you have more general fund dollars that are not associated with the position. They're just utilized as overtime. So what are the impacts if we cut your overtime and just say work within your normal hours? What will happen?
Mr. Chairman, Representative Summers, that would have a significant impact on us to be able to do our job. As the Attorney General mentioned, you know, crime doesn't obviously happen between 8 and 5 and not on the weekends. It's literally every weekend, for the most part, we have at least 1 to 3 or 4 agents being called out. I mean, just for example, this past weekend, we had 2 agents who worked half a Saturday and all a Sunday on a request that was a higher priority. And I want this committee to understand, we absolutely prioritize cases. We look at them from a standpoint of, is it a crime against a person versus a crime that we could maybe wait until Monday or Tuesday to get on. But if you were to reduce all of our overtime, we would have to delay investigations, which would have a significant ripple effect even onto the courts on the delay of that. There's not enough overtime in the grants that we utilize to offset the money we have available in the general fund. So it would be very detrimental.
So I guess the real question, Frosty, is if you have to work on Saturday and Sunday, then you take Tuesday and Wednesday off. And so you do a shift as much as you can because of the special nature of what you do. I presume that you do that as much as you can.
Yeah, Chairman, that is actually something we do look at doing on occasion. But if we get called out on Saturday and Sunday and we go out and work, obviously crimes might happen on Tuesday and Wednesday as well, sir.
Sure, that's why you have 26 investigators and team members. But one of the issues that we have is that, we don't know what you budget for overtime. It's not in your budget. So we don't know what the practice has been in the past. And so, Bridget, I think it would be useful for us because you said you've cut the overtime in half, but it's all embedded in your the 103 budgetary line. So if you do budget for overtime, it seems to me like you ought to have an overtime budget or have a separate category for it so we can follow it. Kevin, go ahead.
Mr. Chairman, we do have objects in, actually there are positions that we use in I-bars that reflect each agency's overtime. And we'll provide you that report. And we'll put the funding on that as well, because I think you'll want to know what the general federal special is. This is the conversation we had with Representative Summers yesterday. But we're working on that report. The information's out there. It is in I-bars, and we'll get it to you as soon as possible.
Great. That'd be great. Representative Stiff.
Mr. Chairman, yes, I just have a general question on your investigations. About what percentage is drugs, controlled substances investigations, and what's other? And then on your controlled substances, are most of your resources being spent on sort of large quantity transactions, or are you spending a significant amount on, lower quantities?
Mr. Chairman, Representative Seth, in 2020, we did approximately so far 489 drug investigations. Out of that 489, at least 50% of those are primarily methamphetamine investigations. The remaining part of those would consist of everything from cocaine, heroin, prescription pills, marijuana, et cetera. In addition to doing 489 drug investigations, in 2020, we've also done approximately 214 general crime investigations to date. When we refer to general crime, the majority of those that we do deal with public corruption, internet crimes against children investigations, arson investigations, sexual assaults, homicides, and officer-involved shootings. Those would be the primary general crime type cases that we do. In relation to your last question, I believe, which was, do our drug investigations involve larger quantities? Am I correct on that, sir? That's always our goal. Certainly there are times where an investigation does not work up to the level where you're getting to the main distributors or primary distributors. But obviously that is always our goal with drug investigations, is to work them up, not only to where we have the opportunity to seize or charge people through conspiracy cases with larger quantities of drugs, but also to do an investigation where we can round up as many of the, for lack of better terms, bad guys as we can and charge as many people as possible.
Representative Summers.
Mr. Chairman, I think my question is going to be for Kevin, or might be easiest answered by Kevin. So Kevin, and I try not to do that too much this time, but when I go back to your chapter 17, which is very dated right now, the 100 series in criminal investigations, basically they don't expend 400,000 of what the budget was. So I'm wondering on what you have today with respect to chapter 17 on the 100 series for criminal investigations, either how much reverted this last go around, which may be the best way to look at it, or, you know, was there a substantial amount reverted? Obviously, if it's overtime, they expended it, but has this 100 series in criminal investigations been reverting money?
Mr. Chairman, the Chapter 17 report is provided on the biennial budget, not in the supplemental budget. We can provide any information that you request. Largely, there is a combination of things that you want to think about when you're thinking about overtime and how the agencies are approaching it. Several agencies have already moved in this direction, you know, the overtime, how do we facilitate that? One of the conversations that we had in 2016 and again 2 years ago was with the Department of Corrections. They do have a significant overtime budget, but that's not how they're paying for their overtime. The majority of their overtime is being paid through their vacant positions because they struggle maintaining their employees. So when somebody has a turnover situation, then you have a vacancy savings thing that naturally takes place that helps us with the payment of overtime. So in the arena of corrections, their overtime budget does not and will not cover their overtime costs. But we do cover those costs through the vacancy savings that we have on vacant positions. So if you would like us, I can work with Steve Winders in the AG's office and get you what their reversions were. But your reversions are probably going to be associated with vacancy savings on position and maybe perhaps overtime that wasn't spent, et cetera. But if you'd like to have that, we'll be happy to provide that to you.
Mr. Chairman, I would like to understand that if we think about cutting overtime, just it's a better understanding. Thank you.
Yes, Mr. Chairman, it's something we've been working on, something that we look at. And also we know how we can position ourselves to address those. But I think the real important thing that'll be enlightening to the Joint Appropriations Committee will be the actual overtime by agency, by division, by unit when we provide that to you.
Okay, please proceed.
All right, Mr. Chairman, then I'm going to move on to our 200 series. You will next see a reduction of 388,000 in our 200 series. The first line that shows on there is a 63,000 reduction. It shows in, and I'm going to confess we made an error here. It shows in state travel. That actually should have been coded in our maintenance. So equipment, repair and maintenance 202. That's what we actually intended to cut in our 200 series.
Tom, did you get that?
Yes, I did.
Okay. Go ahead.
We apologize for that, Mr. Chairman. When we were going through the budget book, and if you saw our explanation for the cut, it clearly explained equipment and repair maintenance, but it on the wrong line there. So we apologize for it. The other one is the $325,000 reduction that was for the radios replacements. That's in 242. You'll recall that from last session. This was the coordinated state plan to replace all the WyoLink radios at one time. That was an exception request, but we're going to try to handle those on a case-by-case basis, which was what our plan was in the event the exception request didn't get granted either. This was just our portion for our agency. You'll recall YDOT was in that, state parks.
Yeah, okay.
That makes up the rest of that one.
Mr. Chairman, just one other question, Mr. Chairman.
Sure.
Mr. Chairman, thank you. You know, on your permanently assigned vehicles, it's a very large number and we're kind of moving away from that, it seems like, to more of the enterprise thing. So can you speak to that and whether you actually expend all of that money on permanently assigned vehicles?
Mr. Chairman, I'm going to let Steve speak to that if he can. We're in a little different situation because they're law enforcement vehicles and the things that we equip them with, but I'll let Steve speak to that.
Sure, Mr. Chairman, Representative Summers. Typically, we do spend all that money. As a matter of fact, it was beginning of this last biennium, we did an exception request to even bolster it up more. So we do have quite a few vehicles and the money does get spent.
Thank you.
Mr. Chairman, that would finish it then for operations. I'll move on to DCI lab. I'll speak a little faster since I'm running over time. Here are that chart for the DCI lab cuts is on page 36. In there, you will first see a cut to our 100 series of $150,388. That's a reduction of a position. This happens to be an evidence technician that we would be cutting there. That position manages evidence coming in and out of DCI. They're also a member of the crime scene response team. So obviously, like all the positions we've talked about, that will slow that work. This one has a particular concern for us, and we'll keep an eye on it, but I just would want to alert you to it. At some point, if we slow down evidence enough, we start to impact criminal trials, and that's a problem, obviously. That's something we can't be doing. But we thought this position, we could try to reassign those duties to other folks and see if we could make a go of that. That's our 100 series cut. You'll see 100,000 in the 200 series as well. Those cuts, the 20,000 would be to eliminate funding for lab supplies. We're going to try to obviously make do, tighten our belt the best that we could, but we will be searching also for places within grants that we could charge those lab supplies to and try to make it work through some of our other grants. So we're gonna be searching for those types of cost savings. The 80,000 then would be to eliminate its exception request funding that we came to you last year for. That was for our GCFID equipment, and that equipment actually quantifies methamphetamine. And so as you know from last year when we were talking to you about it, that machine is starting to have some issues. It's getting older. We will, of course, try to stretch the life of it, but the same as our 20,000, we will try to find a grant that we could try to charge this to or find other funding. But that would be to eliminate the exception request that we made to you last year. Next would be, if there's no questions, our 303 unit, which the chart for that is on page 39. 303 unit is what we call our CJIS, that's Criminal Justice Information Systems. You'll see, first of all, a cut in our 100 series. So that's personnel again. That's 262,720. That actually encompasses two of our priorities on our reduction priority list, and it's eliminating two positions.
Bridget, what's your typical turnaround on background checks?
We're currently at about 30 days. 30 days.
Mr. Chairman, Mr. Williams informs me we're currently at about 30 days.
And so will this slow that down or extend that period?
Mr. Chairman, we believe it will, yes.
Just for an example, you know, you have the special needs services that provide comprehensive care, and their turnaround in their staffing is typically between 20 and 25% a year, which means that they're constantly looking, and they're required by law or by statute or by rule to have background checks within so many times after they hire somebody. And the longer that takes, the longer they have to have someone on staff that they don't know about, but also then while they're waiting for the background check, they can't be out rehiring somebody else. And so it's a substantial cost to them.
Sure.
And then they get chewed up on the front end by your office because they're not following the CDS guidelines. And so it just seems to me that somehow that's just an issue that I've just run into on a regular basis over the last 10 or 15 years. So do you prioritize background checks and where they come from so that you can get them out to those who are more in need? How does that work?
Mr. Chairman, I will let Mr. Williams address that, but I can answer shortly. If you want more details than what I'm offering right now, Frosty can offer those. First, with regard to your comments related to how long it takes for a background check, I do believe I've heard those comments as well, and that's something we were trying to address. Background checks are very important for a lot of different reasons. And so we had already started cross-training people to maybe help us with that. So that's a very recent thing we've started to do. We heard about that since I've become AG, and so we are trying to address that situation, and we'll continue to do that here. With regard to prioritizing, we do that as well. We do prioritize background checks. If you want more details than that in terms of how we prioritize them, I would turn to Frosty.
Well, that's all right. I think I got my point across.
Okay.
I mean, we just need help on it.
Yeah. Mr. Chairman, I would note that we keep adding to the list of categories of folks that need to have a background check. And so your point is well taken. We keep adding on to that. And then it's critical for businesses, especially in schools and all of those things that are having background checks, to get those done as quickly as possible. So we will try to address that situation.
Go ahead.
Next then.
I'm sorry, Representative Summers.
Oh, sorry.
Mr. Chairman, thank you, Bridget. My question on your 200 series there is your dues and licenses of over 858,000 on the 200 series in criminal justice info systems, I guess. So I'd like to know what those dues and licenses are. Is that more hardware licenses, software licenses, or is that something else? And a little more information. And do you actually expend that amount of money?
Mr. Chairman, Representative Summers, those are more of our licenses for the databases that we participate in and our software licenses. So if you'll recall, I think we spoke about this last year, that our database, the costs of our databases that we participate in, it's, if I recall correctly, like 8 or 9 different law enforcement databases that we have to pay to be a member of to do those sort of criminal checks. And so we are spending nearly all of this money. In fact, if you'll recall last time, I think we made an exception request for some of those increased costs to those databases that we need access to be able to do our criminal investigation.
I think we had discussions about charging more for the service last time, just because to certain people had asked for it to help pay for the program.
Mr. Chairman, I think we did too, passing on to, for instance, local law enforcement. And that is something we recall from our last discussion, and obviously something we're exploring as well.
Mr. Chairman?
Go ahead.
Mr. Chairman, just a note on that, as we look at our fee bill, I made the comment back to the committee that most of the fees that the Attorney General has goes back to local government. So or some kind of government. So if you increase fees, you're just cost shifting to another form of government. Is that a fair assumption, Bridget?
Mr. Chairman, Representative Summers, it depends on what the fee is, but yes, a good portion of the ones that DCI would be charging in this realm anyway would be local governments. But obviously we have other fees for people who need fingerprints, that's members of the public. Concealed firearms, that's members of the public. But the fees you're talking about in this realm are more to your local governments.
Right, and Mr. Chairman, the big general fund fee was in the conceal and carry, and whether you want to increase fees to people for conceal and carry. That was the biggest chunk of fees that I saw. Thank you, Mr. Chairman.
Okay, go ahead.
Mr. Chairman.
Hold on. Representative.
Sorry.
Mr. Chairman, Attorney General Hill, just a question in this unit of criminal justice information systems on travel costs. Have you had less? Do you need all that for travel this year?
Mr. Chairman, obviously, we didn't recommend it for cutting. We have tried to limit our travel everywhere. And so it was our belief that this is the travel that we would need. I couldn't say, given halfway through the biennium, whether we think we're okay there or not. When our standard budget was made, we all, I think, committed, because we did listen to what the legislature was saying, right, in terms of cutting all intake state travel, and we are doing our best there. But I would submit we do need this money in order to travel should the need arise.
Go ahead.
Then
Mr.
I
Chairman,
haven't mentioned our 200 series cut. That is two.
Mr. Chairman, I'm sorry, Bridget. Mr. Chairman, I have a noon obligation, so I'm going to have to log off. I'm sorry to miss out on the balance of the
So
presentation.
I have a question, Bridget. How long do you think we'll continue to go before we wrap up?
Well, with no questions, I could be done in 7 minutes.
Okay, let's try that.
Okay. Our 200 series in.
Sorry, Mr. Chairman, sorry not to delay lunch, but Representative Stith's question really, I guess it made me think with travel, and we just heard from the judiciary that their caseloads, their workloads have actually gone up because in part of the accessibility of the courts through technology, through Zoom, et cetera. So just talk to me a little more about accessibility that we have that is facilitated now through the pandemic, Zoom meetings, GoToMeetings, et cetera, courtroom access being all but mostly, actually entirely virtual, even Supreme Court hearings. So going back to that travel budget, it seems to me like it would be positively impacted with the necessity to use less travel funds, but maybe that's not so. Help me understand that a little better.
Sure. Mr. Chairman, Representative Olson, I think everybody would be the first to admit that the pandemic and the ways that we have utilized technology through Zoom and Hangouts, the travel is less currently. But for us in particular, once cases start to pick up again, and this would be agency-wide, so courts are scheduling jury trials, we've got to go places for depositions. Some are being done electronically, but some we've got to go meet with our witnesses. So I do think there will be a reduction, but I feel like it is too soon to tell. With regard to CJIS in particular, part of the reason I believe they have to actually go is some of the data that they have to collect is sensitive data, and they need to go out and do audits, and that would have them going and looking at particular people's books and interacting with local law enforcement agencies. And so I don't know that could be done by the electronic means, but your point is well taken. Look, do we think there might be some reversions in travel? I think there will be, but it's too soon to tell that I would want to put a number on this to tell you could trim from the budget, if that makes sense.
Go ahead.
Thank you, Mr. Chairman. And I guess I would just be curious how those audits would look in the 21st century. I'm familiar, for example, with the Department of Education, who also has an extreme audit burden with the districts because of the federal granting compliance that it has to deal with on a regular basis. I would be curious what they do, and we haven't had them in front of us yet for us to ask the travel question there, but I would wonder if they're able to do most of their compliance now via Zoom or GoTo or whatever. So I'm just not, I guess I'm not exactly sure what has to physically take place in the compliance scenario. Most of it, I would imagine, is document sharing and verifying whether X documents are in place or and it seems to me like maybe that could be done virtually. I'm not sure, maybe it requires visual or wet signatures. I don't know, just, and maybe it might be a good idea to look at some of the other, all agencies do compliance. I'm sure a lot of that could be done virtually even without the pandemic. What has to be done in person with the audits?
Sure. Mr. Chairman, Representative Olson, I think the difference would be the audits we're talking about would be part of criminal investigations. So those are things that, and let me say this too, and I can let Frosty address this more. Obviously, to any extent we can do it electronically and move to electronic, we would like to do that. But we're talking a little bit different here in terms of, we got to go look at dispatch records. We got to go interface with local law enforcement in terms of what they had. And so those things aren't necessarily digitized yet. I understand what you're saying about, you know, a federal audit requirement, and most of that you should be able, you know, they've got the requirements for federal audits, and most of that you should be able to look at electronically. But the difference I see is we're looking for something else in terms of criminal conduct. And so some of that will be a learning curve in terms of people starting to digitize those in our smaller towns, our smaller communities, but they don't necessarily have those capabilities yet either.
Okay, please proceed.
Well, thank you.
Mr. Chairman, I hate to delay lunch, but I just got to ask another question. So, Bridget, you know, and I know it's dated information in Chapter 17, but you go back and look at your Chapter 17 back then, and you spent $3,000 on in-state travel compared to what budgeted, and you spend $450,000 on those licenses versus what you need now at $800,000. I know it's a biennium or two ago, but there are some huge discrepancies in kind of what your 200 series is. So just know that, and that I'm kind of looking at that as I go along.
So do you want a breakdown? You want to just provide a breakdown on it, or?
Mr.
Kevin,
Chairman,
yeah.
there's a fallacy in the Chapter 17 because we're not comparing apples and apples. And when we get to my budget, I'll talk about that in more detail. And we want to get this thing fixed to where it's reflective. We had a lot of conversations during the budget session about the Chapter 17 report. So once we get this thing completed, then the Chapter 17 will be reflective about what the budget amount is and what the expenditure amount is. But now we're comparing one biennium against past biennium's actual expenditures, and it's not reflective.
So the real question is, who's going to be our Chapter 17 guy when Albert's gone?
Mr. Chairman, if we are successful in getting the Chapter 17 report done properly, it'll jump out at you, everybody. You'll say, okay, there it is. This is what they did. They budgeted, and this is what they spent, and the bottom line will be the final answer. So everybody.
Sounds good. Please proceed.
All right. Mr.
Hold
Chairman.
on. Andy, go ahead.
Yeah, I'm looking at office supplies and printing, and I'm actually scrolling through, comparing it to various departments, and 270,000 looks like a lot. Just curious.
Go ahead.
Mr. Chairman, to us, it seemed right. It was our standard budget. I don't know. Yes, Steve's going to have an answer.
That is
for
correct. We have to, included in that number is we have to pay the Department of Transportation for concealed firearm permit cards. And so that eats up a large portion of that funding.
Really, I'm impressed.
$1,000 by
How much is that for concealed firearm cards?
It's approximately $5,000 a month.
About $5,000 a month.
At a minimum.
Okay.
Go ahead. Representative Larson. All right. Further questions?
Follow up? I mean, it's still, you're over 200,000. I looked at the law offices, 170. It's not a big deal. It's just something that caught my eye. You might take a look at it.
Sure. Mr. Chairman, we're happy to take a look at anything you want us to. Obviously, when it came as part of our standard budget, we believe it to be right size, but we're happy to take a look at it and tell you what we're spending that money on. That's fair. We can track that down for you and let you know in this unit in particular why that one seems high. Happy.
Representative Walters.
Chairman,
sorry,
now that brings up another question. Are you charging enough for those concealed firearms permits to cover their expense?
Not on the replacement.
So, Mr. Chairman, Representative Walters, one of the things that we discovered through the exercise that we most recently did with fees would be we believe we are for the initial application. But one thing that we have found is for the renewal, not the renewal. I need to be very careful with my words there. The replacement, we are undercharging for that. And so that is something that we would like to remedy with you all because it is a statutory number. And we would like to remedy that. But other than the replacements, we believe we are charging the right amount.
And we would like to help you remedy that. So give us a little suggestion, a draft bill, and we will fly.
Happy to do so, sir.
All right.
And Mr. Chairman, just on that note, that money goes to the general fund even for the renewal, is that correct? And if it does, wouldn't we want to aim that towards you? Would we want to aim that towards you guys to cover that cost? I mean, both of those issues. Is it a general fund? Should we leave it general fund? Should we put it into a special revenue?
Mr. Chairman, I don't know if he was asking that question to you or if he was asking that question to me.
Yeah, let me answer that. General fund.
Okay. Okay. All right. It would be something we would have to look at from our side in terms of how that would work out. But okay, thank you.
All right, go ahead.
All right, I promised 7 minutes with no questions, so I feel like my time starts now. All right, the page next is our Wyoming Law Enforcement Academy. That chart shows up, that's our unit 501. That chart shows up on page 42. In that unit, you will see the reduction of 149,576. And that's the position that I already hinted at back when I was in the law office, or when I was talking generally about the impacts. This is a financial position. We're going to move those duties here to Cheyenne. That will cause us a little trouble in terms, or a little extra consideration in terms of at the Wyoming Law Enforcement Academy. They're doing a little more than a normal fiscal officer would. They're accepting cash, they're taking credit card payments, and they'll have to sort out those duties a little at the Wyoming Law Enforcement Academy and with our fiscal office. But that will require a few more trips to Douglas than we had in the past, but we think we can swing that and make it work. Next would be, if there's no questions, our post. This is Police Officer Standard and Training. That's 601 is that unit, and that shows up on page 46. What you see there is simply a reduction in general fund, and we're switching that over to the one of our enterprise funds. That is 138,700. That is a position amount that pays our administrator at post. The reason we think we are able to do this, and we did do a little research, we believe that's appropriate indirect cost of training at the Wyoming Law Enforcement Academy. And so we believed when we looked at the statute, I did want to highlight this for you. We believed when we looked at the statute that it would fit as an indirect cost of providing training, because that includes their post certifies all trainings. Post, this verifies and keeps track of the trainings that they have accomplished. And so we thought that was fine in my assessment, that it fit under that statute. But I did want to call it to your attention in the event that you thought something different, because this was a different use of that fund than had ever been used before.
Well, and that my question, Bridget, is that you've got about $1 million in your enterprise fund, and I'm just curious. And so, without a history, we don't really know what revenues come in, what the expenditures and what the balances are as that thing moves along. So I think if you could just provide us information on that, that'd be helpful.
Mr. Chairman, I'd be happy to. We believe there to be enough funding in there that's charged on the advanced training, but absolutely. The one thing we would have to be careful of is, as limits space limits are found at the Wyoming Law Enforcement Academy, that some agencies start doing their own training. But we thought we could still make it work, which means they're doing it at a remote area and they're not paying that fee. But we believe we can make that work. But we'll get you that. I'm happy to get you that information.
Okay.
Next would be 701, the medical review panel. What you see from us in this, and I think you're aware of this because a bill has been drafted, our idea here with the medical review panel, when we were asked to think about cuts, was to look and see if there was any within our agency whole programs that maybe weren't fully utilized, or we're not doing what maybe the legislature intended when you first came up with them.
So Bridget, let me just cut you short. I think we agreed to get rid of this thing.
Excellent. So what you see here is us saving the 100 series, because that's a paralegal. That'll pay for a paralegal that will staff our Casper office. You know, we've got about 5 folks up there. The paralegal staffs them. The rest would be to cut the medical review panel. And you know all the reasons why. That actually isn't very utilized. Most people waive. It rarely goes to hearing. So I will skip on from that then. Thank you. I thought I was going to have to do a long explanation there. Thank you, Mr. Chairman. The next is Unit 901. That is our Division of Victim Services surcharge account. And what you see here is an increase of $83,033 to the surcharge account. And there's a corresponding amount in 915, which is Victim Services Administration. And what we're doing here is splitting the cost of one position between the surcharge account and the general fund. So what you see in this one is us moving half of that salary to here. So that's an increased cost to the surcharge account. When you go over then to our next unit, which is our 915, which is DVS administration, we do have a few cuts there. So the first would be, and so that is on page 60, if you're looking for the chart. That would be the decrease in the 100% or the 100 series, as I talked about, the 83,033, splitting the cost between the general fund and the surcharge account. You then see reduction in our 200 series of $66,901. That's us tightening our belt, and much like we did with doing our best to tighten all our 200 series belt, and then doing our best to find, much like DCI did, some federal grants to charge those monies to. The one thing we like to be very careful about in the Division of Victim Services is to do our very best to not impact the people providing the services to the victims on the ground. That's a very important service that affects people all over the state. And so we've tried to take care of that in this way. You'll also see a reduction of 50,316 in our 900 series. Same principle there, tightening our belt the best we can and looking for some grants that we would be able to fund those with. And lastly then, the last unit we have is our Governor's Council on Developmental Disabilities. That's our unit 1105. That chart shows on page 63. What you see there is a reduction of 174,292. And this is much the same as the explanation we gave in our Medicaid fraud control unit. It would be reducing the state match by 10%. Most of our funds here are federal funds. So the general fund portion of that, it's a 25% state match, a 75 federal funds. So the general fund reduction would be 43,573. That's the portion there, but then of course there's an offsetting amount in federal funds. And you know, this will impact our ability to give scholarships. We would call them scholarships to folks with developmental disabilities, and it's the loss of opportunity for them. The scholarships are generally used for bringing awareness to developmental disability issues. It also, we have that conference, so we use some scholarships to bring people to that conference, the large conference that we have. But we were trying in a lot of ways to offset the cuts we were asked to make and take into account that there would be reductions in services for all.
Mr. Chairman?
Go ahead.
Mr. Chairman, thank you. And Bridget, on this, how much of your 900 series is general fund? And likewise, how much of your 200 series is general fund? And this is just a pet peeve I have on people that cut 600 series and leave operations alone. So I want to know what you spend there in general fund and 900 series.
Mr. Chairman.
Go ahead. Okay.
We're providing an enterprise report on all agencies for their 200 series, 900, 600 series, reflecting the object by funding source. So we're working on that as well. I'm not resistant to have the Attorney General provide that information for you, but we're on it already.
Cool.
Okay,
Go ahead,
then
Bridget.
Mr. Chairman, I'd refine my question then to what do you spend that 900 series on? So if it does turn out to be general funds, I could understand what it is.
Mr. Chairman, so how we account for all of it in this is 2575. So all of our series. So when you say how much of our 200 series, we do the 2575 split with all of our series of money. And so what we spend our 900 on is generally that conference, the contracts related to putting on the conference all together. And again, but that would be the 2575 split. And so this would reduce some attendees by doing it through the 600 to that conference. But if we leave it in the 900, that then allows us still to put the conference on, if that makes sense.
Thank you, Mr. Chairman. That makes sense.
Okay.
Okay, further questions? Seeing none, I think that means you're done.
Thank you, Mr. Chairman. If there's more questions, because I went fast at the end, just let me know.
All right, so committee. Don, anything we need to review before we break for lunch?
Don, you're muted.
Sorry about that, Mr. Chairman. You do have one agency, district attorney from Laramie County scheduled before lunch. We will advise her when to take them up. Did you want to take her office up before the county and prosecuting attorneys were scheduled before lunch? And would you like to take them up before or after the legislation?
Let's do it before.
Okay.
We'll do it right when we get back from lunch. Okay, so it is 12:21. Let's reconvene at 1:30.